All persons having business with the appellate are here, give your attendance, and shall be heard.
Welcome to the Appellate Division, First Department. We have over 7.5 hours of argument time requested, so only ask for the time that you need, not the time that you want. We are familiar with the briefs and the record, and if we have any further questions, we'll keep asking them. People versus Svensson, submitted. Adams versus Legacy Carding Corp. Is there a respondent here?
I'm the respondent. I'm not sure what the...
Is the appellant here? Do you want to submit then?
If they're not here, yes.
Okay, submitted. Chloe is submitted. Alevy versus Herz. Respondent? 4, 1, and 4. And Justice Shulman is recused on that matter. 197 Madison Holdings versus New York State Division of Housing. I'm going to hear both of those appeals together, so the time I'm going to give you is for both of them. Appellant? Respondent? 5, 1, and 6. Sweet Pea Ventures versus Belmamoon, appellant.
And at 6 minutes 4 and 5 minutes 05.
Respondent? 6, 1, and 6. People versus Malero, submitted. People versus Martinez. 2, 1, and 2. Cox versus Senior Care Emergency. Are you appellant? Respondent? 5, 2, and 5. Board of Managers versus Soho Broom Condos, appellant?
6 and 3 for appellant, Your Honor.
Respondent? 6, 1, and 6. People versus Haskins, appellant?
5 and 2 for appellant, Your Honor.
Respondent?
Respondent request 4.
5, 1, and 4. Newman versus New York City Housing Authority, appellant?
Respondent 4 and 2, Your Honor.
I'll actually give you 4 and 2 and 4 and 2. People versus Agilar, appellant?
Appellant request 6 and 2, Your Honor.
Respondent? 6, 1, and 5. People versus Clark is submitted. Rockefeller University versus Etna Casualty, appellant? Respondent? 8, 1, and 8. Windmar Properties versus City of New York, appellant?
Appellant request 6 and 3.
Is there a respondent here?
Respondent request
6, 1, and 6. The next two, I'm going to give you separate time, but they're going to be the same arguments or similar arguments. People versus Rivera, appellant? Okay. Okay, so I'll just, do you agree to be submitted?
Yes, Your Honor. Unless Your Honors have any questions that you don't think I will have time to answer in the second case.
No, I'll mark it submitted. People versus Rodriguez, appellant? Respondent? 6, 1, and 5. Schneider versus 254 Paz Property is submitted. Lamarique versus Columbia University is submitted. And John Doe versus Archdiocese is submitted. So our first case is Alevy versus Herz, and Justice Shulman is recused on that matter. Go ahead.
And just let me know when I can begin. I can go?
Go ahead.
Yeah. Okay, thank you. May it please the court, your honors, my name is Rivka Herz, and I am the appellant in this case. The first issue that concerns me with regard to this judgment is the lack of personal jurisdiction in the California court. It may be argued that by filing an answer in the California case, I submitted to the court's jurisdiction. However, this interpretation misrepresents both the facts and the law. From the outset, my answer expressly contested jurisdiction, and all subsequent procedural actions, such as requesting an adjournment, were defensive in nature, aimed solely at preserving my right to challenge jurisdiction, not in engaging with the merits of the case. International Shoe versus Washington is actually a case that actually supports that. Personal jurisdiction requires continued, substantial, and systematic contacts with the forum state. My contacts with California were minimal, and they don't meet the standards of substantial or continual contacts. Another case is Culco versus Superior Court of California. My actions were not directed at California in any sustained or deliberate manner, and this jurisdiction that they granted in California was improperly asserted. With regard to minimal contacts, in Calder versus Jones, mere contact with the state is insufficient for jurisdiction. For jurisdiction to be proper, the contacts must be purposeful and substantial. In my case, your honors, the emails and phone calls were incidental, not part of any deliberate or sustained effort to engage with California's legal or economic systems. These communications were neither systematic nor directed specifically at California. The contacts they cite are too isolated and disconnected from the claims at issue, making them insufficient under the standard with Calder. The lack of personal jurisdiction in this case directly resulted in a violation of my due process rights. Due process requires that a party be given a fair and meaningful opportunity to challenge the claims brought against them, such as in Mullane versus Central Hanover Bank and Trust. Due process is violated when a party is denied a proper opportunity to be heard. I was denied my ability to defend myself, and the trial proceeded based on faulty assumptions about jurisdiction. The next issue I want to discuss is fraud on the court versus fraudulent evidence, and not just versus, but both. We claimed fraud on the court in our papers. We met all the standards, we ticked off all the boxes. Unfortunately, the judge did not agree. However, separate and apart from fraud on the court is fraudulent evidence. Fraud on the court is a term of art. I'm sure I don't have to teach you about that, but I myself learned. Fraudulent evidence is something entirely different. When the respondent introduced detailed information about a website claiming it was a source of defamation, the level of detail they provided regarding the back end of the website, the testimony that 5 people related to the plaintiffs in various cases, both in California and in New York, testified to with regard to the website, etc., prove that whoever made these statements were actually the ones who controlled the website and had...
If I may,
Sure.
can you explain how there was fraud on the court, and we're talking about that website, when the court did not even rely on that in rendering the judgment? How was there fraud on the court when the wall of, I hope I'm saying it right, yeah, the wall of shame website wasn't even addressed by the court?
Forgive me, Your Honor, I do believe that it was addressed by the court. It was brought up as part of the evidence against me.
The court didn't rely on it, for sure. I mean, my reading, the court didn't rely on it.
We're talking about the court in California? Or the court in New York that's just enforcing the judgment of California?
Yeah.
So the court in California, as far as I remember, and I obviously don't have all the documents in front of me now, I came pretty empty, did rely on it. It did make it as one of the points used against me. It was used both in California, it was used in New York as well.
Justice Kern, may I pose one more question? If not, then I'll just wait.
Go ahead. You could do it on rebuttal.
Yeah, I'll wait. Thank you.
I didn't
Thank
realize
you.
that
No, your
minutes.
time's up. Opposing counsel can speak.
May it please the court, John Hofstas of Westland Real Estate Group on behalf of respondents, Alan Alevy, Dan Alevy, and Amusement Industry Inc. doing business as Westland Real Estate Group. In this matter, Your Honors, respondents are entitled to full faith and credit with the domesticated California judgment under CPLR 5402B and INESCO, where this department said that so long as jurisdiction has been obtained, a defendant's default in the rendering state will not nullify the res judicata effect of the judgment, and full faith and credit doctrine still applies. In UNESCO, this department refused to address collateral issues related to fraud. That's exactly what is happening here. And it stated that the fact that UNESCO's fraud and misrepresentation claims are never litigated on the merits in the New Jersey action does not alter the outcome. That's the same thing that should happen here, Your Honor. This is collateral issues that are being brought up with the sister state's judgment that is entitled to full faith and credit. And it might even be...
Is that because of res judicata?
Yes, Your Honor, I think there would be res judicata on the issues. That she was able to bring up those issues related to fraud. She was able to bring up any of the issues she states related to the website. She entered her answer, she made a journal appearance in California, and then she failed to contest those issues. There was also admissions that were made based on requests for admissions that were not answered, that were served on her here in New York. She was given an opportunity to have a deposition here in New York. She didn't avail herself of any of these things. It would have been easy for her to contest that matter in California, but she failed to do so. And so all the findings that were made in the California court case should be honored here. In terms of process, all the requirements are met.
They're honored in the sense that as long as there's jurisdiction for the California courts, that's it. We're bound by, it's pretty much
Correct, Your Honor.
It's Con Law 101, right?
Correct, Your Honor. It's binding. It may even be unconstitutional to adjust those findings related to the fraud or to challenge those. In terms of minimum contacts, there should be no concerns for this court because similar to Calder versus Jones and similar to Yahoo Inc. versus La Sig Contraire La Racissime, there's a three-part test that's required. She's clearly met all three parts of those tests because she directed specific communications. We're talking not one email, not two emails. There was 21 employees of a California business entity that received emails making allegations that the founders of the company were criminals.
Isn't your argument that we shouldn't get into the merits of the jurisdictional argument because we're bound by the proceedings in California?
I understand, Your Honor, and my point
No,
is
I'm
just
not
this.
asking if you understand. I'm asking, isn't that your position, that we shouldn't get involved in?
I don't think that you should get involved in the merits of that, but it's a fact
Then
that
why are you arguing it if you don't think we should?
because there's I just want
Friendly
to show
question, it's really a friendly question.
I just want to show the degree of contacts that were made with California specifically related to this particular matter. So there's 21 employees who were contacted.
But again, your argument, I think, is that we don't get into jurisdiction here because she appeared in California. And under IONESCO, that ends the inquiry.
Right. If the court is willing to consider personal jurisdiction as opposed to fraud or other collateral arguments, that was the only point I was raising. Thank you, Your Honor.
Thank you. Do you want to ask your question?
No, there's no need. Thank you.
May I continue? Thank you. So getting back to a response here and then continuing with my points, there was no jurisdiction in California is my point. If in fact there was jurisdiction, it would be one thing. What I had mentioned previously is that as far as I'm concerned, there was no jurisdiction, and the only reason a quote-unquote appearance was made was to be able to state, you guys don't have jurisdiction over me. It was the only thing I knew to do. With regard to minimal context, there was even a judge in this Supreme Court in New York on a related case against me that had said there were no minimal contacts in that case, and we brought that up in our papers. In addition to that, full faith and credit, I'll work backwards. Full faith and credit, the U.S. Supreme Court in Funterloy versus Loom says full faith and credit does not apply when the judgment was obtained without jurisdiction or through fraud. Both of those apply over here, both exceptions in my case, which is my point. These factors...
Thank you. Your time's up now, but thank you very much.
Thank you.
Thank you.
197 Madison Holdings.
Thank you.
Go ahead.
Good afternoon, Your Honors. May it please the Court, my name is Brian Shaw for the appellant. The court below should be reversed because there's nothing in the record that demonstrates what, if any, rent was paid by the prior tenant to the prior landlord in excess of the legal collectible rent.
Counsel, that goes to the heart of this matter. Whose burden is it to establish how much rent was or was not paid? Isn't it the owner's burden in the first instance to show that the rent that was actually in the lease was not actually collected?
It's not. I think it's the owner's burden to establish the legal rent. And the case law is clear. The directives are clear that the landlord needs to keep records in order to establish the legal rent. Once a complaint is made that legal rent, a rent is paid in excess of that legal rent, it's the complainant's burden, just like in
Right,
any.
but you're assuming DHCR is a complainant, but DHCR is not a complainant. DHCR is the agency that does the fact-finding, so they're not the complainant. But since we have in the record already leases, and those leases indicate a rent that was collected, why isn't it then the burden of the owner to show that the amounts articulated in those leases are not the amounts that were actually collected?
Because the lease is an amount that's collected, it's amounts that's promised to be paid. And in the instance of a rent reduction order, the rent reduction order doesn't affect the lease rent. So the lease rent's always going to stay the same, and the rent reduction order is going to require rent that's less than the lease rent. So in that instance, in order to reserve the rent, the landlord has to include the legal rent in the lease. And then the proper procedure is to collect the lower rent. There's
Okay,
nothing.
but since DHCR is the fact finder here, they're not the complainant, in the capacity that the rent overcharge is decided, if it's not the owner's burden,
Then it's the
whose
tenant.
burden?
The tenant. The
The tenant's not bringing this complaint.
tenant has the option to join in the complaint, and the person who is the beneficiary of an overcharge
I'm trying to understand your argument, because DHCR is the agency that's making the determination. And the DHCR is saying, hey, owner, there's been an overcharge here. Don't you then have an obligation to show proof that there has not been an overcharge?
But they aren't saying there's an overcharge here. They're saying that the TPU sent it to DHCR and said all the increases to the legal rent are improper. And we said they are, and here are the proofs. And then the agency found that we were correct, the legal rent was proper, but no one ever said an overcharge was collected. They just said, give us your rent ledgers, which we didn't have because we weren't the owners then. We're not required to obtain those records. And the apartment was vacant at the time that my client bought the building. So there were no rent records to obtain for a current tenant. It was vacant. So in that instance, it would be improperly shifting the burden to my client to disprove an overcharge when there's nothing.
Was there a rent reduction order in place when your client bought the building?
It was, and
Right.
And
so
the
your
apartment
client-
was vacant when he bought it, and he kept it vacant until the rent reduction order was lifted.
Yeah, but there was, I think, during the rent reduction order, wasn't there someone else living there during that
Sure.
period? And the rent was charged above the order?
It was pursuant to the lease, correct. But again, the proper procedure is include that rent in the lease, but only collect the lower
Yeah,
rent.
but as a successor owner, you're kind of charged with whatever your predecessor had, right? It passes through you.
Correct, if there's something in the record that says that rent was actually paid.
Well, you got to do due diligence. You're buying a building, you got to make sure that everything there is on the up and up, right? You don't just buy the building and say, okay.
The due diligence is complying with the requirements of the DHCR, which is to establish the legal rent of the building,
But
of
the
the
due
apartment.
diligence is on your client as the new owner, as the new building owner, to make sure that you're known it's a rent-stabilized building. You've got to make sure that every apartment is copacetic, as they say.
As far as the legal rent, correct. But if there's an overcharge that's brought, you're basically presuming that an overcharge is collected. And there's nothing in the statute that says you can presume that the rent was
But
collected.
you're saying that you did not even know when you bought this apartment about the DHCR proceedings.
So to be put on notice to say, hey, we should get the rent payment records, we were never put on notice of that. We got the notice in April of 2019.
But what Judge Oing is saying, when you're buying a building, it would seem that you would do due diligence to find out if there was some type of litigation or proceedings going on which you didn't know, or to figure out, what rent had been paid. But you didn't put in any proof of whether you had gotten any rent, whether it was the registered rent, the legal rent, the above market rent, the free in a market rent? I mean, there was no proof of any rent.
That's still improperly shifting the burden of proof to the defendant of an action to disprove the cause of action, which there's nothing in the statute that says that that's the requirement. In fact, the statute specifically says the landlord has the burden of proving that an overcharge wasn't willful in order to avoid treble damages.
Thank you.
May I?
Go ahead.
Counsel, if you've analyzed the statute as it evolved, particularly after the HSTPA was enacted, it seemed clear when you look at the totality of the statute that they put the burden on the landlord in almost most cases. And while the tenant just simply had to put in an allegation of overcharge. So the burden then shifts to you. So the TPU is wearing, is in a sense, is representing, so to speak, the tenant in their initial investigation. That's how it works. And while it seems unfair, the statute and case law seem to really put the burden on you.
Justice Silverman, I would agree with you if there was an allegation. If the tenant said, I paid an overcharge, that's enough to shift the burden of proof to me. There's not even an allegation that there was an overcharge paid.
Thank you.
Good afternoon. My name is Kathleen Lamar. I'm with the Office of Mark Palomino, Counsel to the New York State Division of Housing and Community Renewal. Number one, the whole issue is here whether the order was arbitrary, capricious. The two judges decided that based on the record, based on the situation, based on the law, which is misspoken here, there is an obligation to get rent records, including rent ledgers up to 4 years
What
before.
about the argument that there's no complaint in here? No one has come forward and said, there's been a rent overcharge that has to be addressed.
The answer to that is basically that the law itself gives DHCR and the TPU, as amended especially by HISPA and as stated in the Second Department's Portofino case, the right to process these complaints, the right to bring them, and we, even before HISPA, DHCR had a right to initiate its own complaint. Or initiate its own proceedings, but that does not negate the burden of the owner to keep the rent records required under the law. And the case law cited in my brief and in other cases states that that just doesn't include leases. If that just included leases, an owner could just put a lease in and never would have to show that there was no overcharge. Say, I put the lease in, you know, it's enough. I don't have to counteract that that's the lease. And there was an overcharge in this case. Even given everything they claimed, for both of these apartments, there was over $1,000 overcharge. Even if you take out the rent reduction orders, there was an overcharge. So to say that the lease contained the legal regulated rent, it did not. And as a matter of fact, one of those apartments were claimed to be exempt, even though the legal rent never reached the threshold. So this is another reason why the integrity of the system is to protect not just this landlord, or not just these parties, but the integrity of the system. And that's why the TPU was set up. That's why the legislature, and even straightened through HISPA, gave DHCR the right and the obligation to do these type of audits, to do these type of proceedings, and try to protect. It's really an overreaching of making sure the system's integrity, that the owners are fulfilling their obligations, which clearly this owner wasn't. I mean, he didn't, nowhere does he give an excuse on, except that I don't have to get rent records except for leases, and if an apartment's vacant. I mean,
Ms. Lamar, I'm just curious. I don't recall in my former life dealing with where the agency acts as a representative for a tenant who didn't complain. Well, neither of these two tenants in apartment 1114 filed a formal complaint. So I'm just curious. The orders that you're seeking that were affirmed and ultimately seeking to have the Article 78 dismissed, how are these orders enforced? Do you track down these tenants? We're talking about serious five-figure awards here.
The orders are sent to the apartment, and it's up to the tenants whether they want to, file a judgment or not, whether they choose to proceed with it or not. The order gives them ability, but once again, as with any overcharge order, with any tenant, you can get an order and just let it sit there, or you can act on it. So it's up to the tenant if they're still there. If not.
But we had no tenants here.
Well, there were tenants.
There were tenants that were there from 2014,
Right,
et
we
cetera.
do try to track them down, but if they're not tracked down, then it's there if they ever choose for the 20 years or whatever to convert it.
So to finish that thought, what happens then? If you get this and you, everything gets affirmed all the way up, you know, there's an overcharge, what happens next? I mean,
Well,
you're saying it rightfully belongs to the tenant, right? So if you can't find them, does it not get paid?
Well, number one, going forward, the rent has to be adjusted.
Right.
So for future tenants, the rent has to be
Yes,
adjusted.
talk about the past.
You know, we do notify the tenants this is going on. We do give them an option. We do try to track them down.
Zero,
but
nothing
it-
comes up.
Some do participate, some choose not to, but that's the point why these things should happen, because it's just a way, if we don't do these things, then owners will have the ability
Right, you always have to have an eye on everything.
to circumvent
no
the
question.
law. So if the judgment is fulfilled, then good for the tenants. If it's not, they do have an obligation on their own at
No.
some point to fulfill their own reward,
Right,
their own
Oversight's
refund.
good, correct, no problem.
If I may, now, there's no dispute that the 2000 reduction order was in effect during the tenancies 2014, 2015. My question is, what, if any, proof did the owner submit to indicate that it collected rent less than what was cited in the leases?
Absolutely none. And there was no they cite the Zumbu case, but in that case, the owner actually put the lower rent in the registration. Here, they didn't register one because they claimed they didn't exempt. And the second one, there was just the legal rent that they put into the register. Well, actually, it was the illegal rent because it was the higher rent.
Thank you.
Okay, thank you.
Thank you very much.
I'm not arguing that the HCR can't bring these cases or they shouldn't have oversight over this type of situation, but once they do, there has to be some allegation, even affidavit or saying, I paid an overcharge. Something as simple as that, to say, now put the burden on me. There's nothing of that effect. No one's saying I paid an overcharge. So then, in the absence of that, you're putting a defendant or
But see, that's the thing I'm having trouble with, is like, you know, you need a tenant, right? And someone's got to say, someone's
Yes.
got to be visiting.
And
there was
what
an
happens to my
overcharge.
client now is, for the next 20
got a
years,
ghost.
I can't sell the building because I have $200,000 worth of potential judgments against it, or I lose $200,000 on my purchase price. But you know, we never said you only have to produce leases. There's not a single case cited by DHCR, not a single regulation, not a single advisory opinion that says landlords have to keep proof of payment of rent. They have to keep records such as AII increases,
AIA, right.
Right.
you know, leases, construction contracts, affidavits from contractors. We produced all that. We produced the things we had to do. But there's not one authority that says we have to.
So I'm going to ask you a silly question.
I'm sure that it's not.
You always have the ability, given that from your point of view, you claim you've been victimized because you thought you got empty apartments and you should have been home free because that went into your purchase price. So you really have a claim against the prior owner. Why couldn't you reach out to the prior owner and get records from the prior owner that might help have resolved whether there was actual rent collected for these apartments?
I mean, it's not in the
Pretty
record,
simple.
but we did. We always do that. And exactly, they didn't want to exactly be, you know, cooperative, unfortunately. Whether they destroyed them, you know, I believe actually in the record, my client says that, you know, there is a statement in one of the letters that we tried, they weren't available, they didn't have them. Because when you think about it, this apartment was vacant. Once the apartment is vacant, you don't really need proof, for the most part, you don't need a proof of payment for a non-payment case
Thank you.
or for any type of other litigation.
Thank you very much.
Thank you.
Sweet Pea Ventures versus Belmont.
Your Honor, you allotted me 6 and 1. Could I reallocate the same 7 minutes to 4 and 3?
Sure. Starting now, though.
This is an appeal from that portion of the decision below that
Want to bring the
grant.
microphone down a little bit?
This is an appeal from that portion of the decision below that granted an award of attorney's fees pursuant to New York Civil Rights Law 76A, commonly referred to New York's anti-SLAPP legislation. Historically, the anti-SLAPP legislation is only applied to matters in the public interest.
Well, there's two provisions in the civil rights law. One talks about the public interest, but the other talks about the right to public petition. Why isn't this number 2, the right to public petition, covered by the SLAPP law?
It is.
So why isn't that covered under the anti-SLAPP statute, since it invokes the right to public petition?
Because the anti-SLAPP decision legislation only applies to matters of public interest, and public interest is defined as not including purely private matters.
Then
And
what are you doing about Section 2 of the civil rights law?
I refer to the decision of this court issued just a few months ago in
That court wasn't, you're talking about Reeves?
Reeves, yes.
That court wasn't addressing the issue that's before us. That court was addressing a completely different issue.
Right.
That case had nothing to do with the issue of the right to petition and whether that was covered under the anti-SLAPP statute.
Are you saying that public interest and purely private matters don't apply to any case?
You can't ask us questions. We ask you questions.
You're pulling rank on me. To take that interpretation, that narrow interpretation, that would mean that any case that any lawsuit that has a chilling effect on bringing a lawsuit or continuing a lawsuit would have to have SLAPP applied to it. That would include any case, any lawsuit for malicious prosecution, any lawsuit for
You'd have
abuse.
to show it's frivolous, right?
What?
You'd have to show it's frivolous. To invoke the anti-SLAPP statute, you have to show there's no basis for the action.
Yes, but in
That's a big break.
so that you have the frivolous statute. Are you saying that any time a frivolous statute would apply?
Again, you can't ask me questions.
Sorry.
I'm saying, though, that you should look at the Civil Rights Law, Section 2, and you have to grapple with what it says.
Yes, well,
Because Section 2 doesn't refer to public interest. It refers to any other lawful conduct in furtherance of an exercise of the constitutional right of petition. That's what the statute says. So that's what you have to.
so is the constant, then what are we going to be defining the constitutional right of petition? Is it limited
So,
only
counsel,
to
the way I understand, since I was intimately involved in the Reeves decision, is that your safety valve is that you have to demonstrate that it's a substantial basis. If there's a substantial basis for the lawsuit, you're out of the anti-SLAPP statute. Then you're fine. You're good to go, right? That's the safety net for everybody. That if you're going to commence an action, you know, arguably if it's frivolous, it's not frivolous, whatever, meritorious, the whole analysis then boils down to if you're going to have to get but if you're going to get imposed attorney's fees imposed on you, you have to demonstrate that there was a substantial basis for the lawsuit. Okay, so I hear what you're saying, but that's it.
You have a question?
No.
Okay, thank you. You'll have 3 minutes in rebuttal.
Thank you.
May it please the court, Michael Dvorkin for the respondent. It's settled law in this court, in the United States Supreme Court, that bringing a lawsuit is covered by the constitutional right to petition. That's settled law. The only issue in this case is the meaning of the words in the second clause of A1A2. That clause has not been in any other case. It hasn't been decided in any other case. All of these cases that talk about, and all of you have sat on a SLAPP case, I know that, and made decisions, but all of those decisions involved free speech or whether it was a public forum, and they all involved Clause A1. None of them involved Clause A2.
So you raised this below with the trial judge.
Of course.
The issue of this section as well as the Court Rule 130-1.1, which is somewhat analogous, right?
But he didn't reach 130. But not only did we raise it in our brief. Judge Reed raised it at oral argument. He raised.
The thing that was curious was that when I was reading the decision below, I thought I was gearing up for a substantial basis argument, right? In terms of not having you entitled to attorney's fees under the anti-SLAPP statute. And then I'm reading it, that's not what it was turning on. It turned on whether or not this falls into the subdivision 2 the definition, right?
Well, he found there was no substantial basis, and they don't challenge that on appeal.
That's what
It's not an issue here.
Right.
So the only question is, what do those words mean? And those words are plain on, there's 3 reasons why we win. Those words are plain on their face. They mean unambiguously a petition, which is covered by the constitutional right to petition, is a lawsuit. And no other case has had a situation like this where there's been a lawsuit first. They've all just involved free speech in the abstract.
Just thinking it through, right? The anti-SLAPP statute protects those who commence actions for whatever reason, some for altruistic reasons, some for safety reasons, so forth and so forth. So it would be reasonable for the legislature to make that change to say public petition, right?
On top of that, the second clause is superfluous if it doesn't cover this situation. And we know that a cardinal rule of construction is we don't interpret words to be superfluous. We give them meaning, and the only meaning those words have is what we have here. And on top of that, you don't have to take my word for it, because 25 years ago, the California Supreme Court in Briggs, which is cited in our brief at 2122, faced exactly this situation under the California law, which the New York law in large part adopted word for word. California law has 2 clauses that have the word public interest in them, that deal with free speech generally, and they have 2 clauses that deal with the right of petition to an official body. And the court there did exactly what I'm asking you to do here, which said the words public interest are not in the clauses that deal with the right of petition, therefore there doesn't have to be a public interest requirement. And none of the cases that they've cited, and not only that, they've ignored this issue.
Are there any cases from the First Department or from any of the appellate divisions that address the second clause?
No.
So this is the first time we're addressing it?
None. There are none.
Is there any argument that was made by opposing counsel that the right of petition doesn't
with all
include?
respect
Wait, let me finish.
Sorry, I apologize.
Let me finish my question.
I have one
That the
eye on
right
the
of petition doesn't include litigation somehow?
No. And this is this court in Northern Leasing and the Supreme Court numerous times said that the right to petition includes not just the right to go out in the street, not just the right to petition the legislature, it includes the right to petition courts. And more importantly, we raised this in our brief below. Justice Reed at oral argument said, what about the right to petition? They didn't answer it there. They didn't mention it in their opening brief. And when we came in our opposing brief and hit it hard and explained why we were right, they don't say a word about it in the reply brief. They just completely ignore the argument, just as they completely ignore the clause.
Sir, when did they withdraw? I know during the bench, during the transcript, there was a discussion that they withdrew the underlying action based on the fact that it wasn't withdrawn?
They stipulated a few days before argument.
Right.
They withdrew the action they filed, the claim against my law firm.
Great.
They did not, that's all they withdrew.
That's all
they conceded at oral argument. As I say in my brief, they had no basis to bring in the first place. This was purely a retaliatory strike action after 6 or 7 other actions they lost in Morocco and in the federal court, deep-pocketed party to go after Mr. Belmamoon, costing him a fortune to defend this. This is the classic thing that the SLAPP Act is intended to protect against. And I really do urge you to read Briggs, which is the California Supreme Court. It's been followed for 25 years in California with no problems. It protects private litigation, explicitly holds it protects private litigation. It's worked well in California. The legislature was clearly trying to expand the New York law to copy California. And this court twice, the appellate divisions in this court have cited California cases as examples of what they should follow when interpreting the SLAPP Act. So it's not a foreign thing to do.
Thank you.
think the issue is whether the right to petition is elevated above all other rights of free speech to
What about
that.
his argument that you have, and my question, that you have to grapple with Section 2, and how are you grappling with it?
We did, by the way, we did address this, I'm referring to.
What's your
page
answer
4 of my
now
moving
about Section 2? How could that not include the right to petition, which is the right to litigation?
Of course it includes it, but that doesn't mean that it doesn't exclude purely private matters.
But it says or, so where does, if it's or public petition, where does the public interest come in?
Perhaps there was an error of drafting, having worked with the
You're,
legislature.
you're supposed to say, we're supposed to find that the
You're supposed to find
the
that
legislature
legislative-
didn't mean what it said?
No, the exclusion could be accidental, that it was clearly the purpose of the court, of the legislation, to expand the scope of the application.
Would that be particularly surprising in light of California, and California having that rule for 25 years?
But you didn't follow California's language. We chose our own. We were always more conservative than California.
So it seems that this may be something that may have to be taken up with the legislature, but right now, we can't assume that they made a mistake.
Is there anything from the reading of the statute that would seem to elevate the right to bring a court proceeding over all other rights of public expression? Why shouldn't the same standard apply to all? I think that
We're not doing policy arguments, so we're reading the statute.
I think a fair reading of the statute would just mean to make it clear that any right to a lawsuit, even though it may not seem public because you file privately, is covered by the statute. I don't think it was meant to exalt the one forum above all others. And I did address some cases in page 4 of my moving brief. I quoted Soho Partners versus 1600 11th Street. I mean, it's only Supreme Court.
Counsel, you know, Counsel, I'm just thinking, I'm listening to your approach, and, you know, with respect to that clause, you're saying, look, it's a public petition, but it's really a pure private matter, so it couldn't possibly cover this, right?
That's
But if I were to agree with you, that would be sort of like, where do you draw the line? I mean, it's like it's a slippery slope at that point, right? Is this going to be something that's private purely? What if it's a mixed bag of private and public, you know, when it comes to commencing a lawsuit?
Anything that is purely private should not be covered by.
There's so many legal books behind me, you know, that have all these questions about if it's, you know, it's hard to discern, right?
Well, that is for the courts to discern. Everything is a slippery slope. Everything is a continuum.
Thank you. Thank you very much. No, no. The next case is People versus Martinez.
Good afternoon. Center for Appellate Litigation by Molly Booth on behalf of Mr. Martinez. I just have two things I want to say regarding the excessive sentence point. The prosecution suggested that my client got the near minimum sentence in their brief, and I just want to point out that my client did receive the statutory maximum for the crime to which he pled, and that was 3.5 to 7 years. I also want to draw to the court's attention that the prosecution implies that my client fired shots on a city street, and my goodness, if that were proved or even alleged at any point, that would be extremely important in evaluating whether his sentence was excessive. I want to call the court's attention to the fact that he was never even charged with either reckless endangerment, and while the top count on the indictment was criminal possession of a weapon in the 2nd degree, it was not with intent to use unlawfully. And so those were not the allegations. They didn't make it to a complaint, and they certainly didn't make it to a grand jury, and they were never part of any admission that he made. And those are the 2 points that I think are germane to excessive sentence that I wanted to draw this court's attention to.
Thank you.
Good afternoon. May it please the court. Jonathan Sklar for the Office of Darcel D. Clark. Your Honor, seconds after hearing 2 gunshots fired, police found defendant with a gun in his hand. When he saw the police, he ran up to an apartment, locked the door with a woman and her child inside. The obvious inference is that he had been the one that just fired those guns. Now, we didn't charge it. She's correct. She didn't misstate anything. But come on, right? He received an extraordinary benefit. He could have received his second felony offender. He could have received up to 15 years. Instead, he negotiated a sentence of 3 to 6 years, indeterminate. When he was supposed to show up for sentencing, he was rearrested for a criminal sale of a controlled substance. Thereby, the court gave him 3.5 to 7 years. The benefit was extraordinary, Your Honor. This was his 3rd felony conviction. He had multiple misdemeanor convictions. If Your Honors have no questions, we ask that you affirm. Thank you.
Thank you.
I just don't believe that an obvious inference, it can be that obvious if it was not chosen to be either charged or put to a grand jury. I'm sure the district attorney's office has rarely hesitated to charge a shooting when they can charge a shooting. There was a hearing in this case. The plea happened after the hearing. My client lost the hearing, but there were some facts put on the record that questioned the credibility of some of the facts that the prosecution recites to this court. And so I'd urge this court, when considering this or other excessive sentence briefs, to consider what has been either proven by an admission or even made it past a grand jury.
I do have a question. Now, there was a waiver of appeal in this case, right?
Yes.
Now, you know, in the event that the waiver is valid, how would that affect, you know, the review of your excessive sentence claim?
Well, I would argue here that the waiver is invalid.
No, if it was valid, how would that affect your excessive sentence claim?
I don't think that we would be able to bring that claim. It's my argument it was invalid.
All right. Thank you.
Thank you.
Cox versus Senior Care Emergency.
Good afternoon, Your Honors. Monica Romero for Senior Care Emergency. And I would like to focus on a
Just
point.
speak up or speak more.
Of course. Is that better? Okay. And that is that appellant has met its burden under the summary judgment standard to prove that he was not negligent in the incident. And the burden shifted to the plaintiff, and they did not submit any admissible evidence whatsoever to prove that there remain any questions of fact.
What about the evidence in the record that there was some speeding on the part of the defendant at the time the accident occurred? Wouldn't that be evidence of comparative fault?
I don't believe so, Your Honor. There are 3 points that I would like to make about that. The first one is that we did not highlight this in our briefs, but we should have, is that the speed limit is 65 right before the accident.
Wasn't that disputed? Isn't there some testimony that, or something in the record that it was 55?
Mm-hmm. So the speed limit is 65, 5 miles prior to the accident, and it's 55, quarter of a mile after the accident site. So in between the 2 speed limit signs, that's where the accident happens.
Didn't you at some point in the record concede that the speed limit was 55? I saw the different evidence, but I thought you had sort of conceded that at some point.
We noted that it was part of the area, but it has always been part of the record that in that area where the accident happened, it's 65. It's part of the expert report that was submitted to the court below. So it has always been part of the record. It's pages 399 of the record to 403. So we believe that the speed limit is 65 because it's the last speed limit sign that the defendant sees prior to the accident, and not 55. The second is that the speed is irrelevant because the accident would have happened anyway. Even if the defendant had been driving at 55 miles per hour, it would have happened either way.
Let me ask you, isn't there also some statement on his part that could be interpreted that he was not completely observing at all times what was occurring? That he turned away at one point?
I believe I remember those statements being more so that he noticed plaintiff on the roadside, and then the assumption that he had to keep track of the plaintiff. But I don't believe that that's a reasonable interpretation of how a driver is supposed to behave, right? Because you have to keep an awareness of all of the vehicles around you, so you cannot keep your eye on this one vehicle in the road. You have to pay attention to all of the vehicles that are around you.
Counsel,
yes.
so let's accept for purposes of your argument that you met your prima facie burden under the so-called emergency doctrine. Then it shifts, and they have an accident reconstruction expert that came in there and determined, based on what was conceded to be your client going 71 miles an hour, at least that's what it said in the record, 65, 55, as far as I know, 71 still above the speed limit. And we know that when you're going at a particular speed, but based on various factors as to braking and distance and all that other stuff that these accident experts seem to be good at, they basically said that had you been not going as fast as you've gone, you could potentially have avoided hitting the plaintiff, even though the plaintiff made an illegal U-turn. Doesn't that create an issue of fact?
Well, they did not submit any admissible evidence. Their expert report was thrown out because they did not submit their qualifications. So there's no way to know that we can trust the expert report that they submitted. They just never submitted the qualifications, and that was the argument that was made below. But we believe that the evidence conclusively shows that regardless of the speed that the defendant was driving at, the accident would have happened. We included that. And regardless, a driver that has a right-of-way and only has a few seconds to react, it's not comparatively negligent. And in this case, our expert included that our driver had only less than 3.3 seconds to react. Less than, not even the 3.3 seconds. And unless the court has any questions.
Thank you.
Good afternoon. May it please the court. Evelyn Sohe for plaintiff respondent Thomas Cox.
You know, address the issue about the speed limit and dispute about whether the speed limit was 55 or 65.
So that is at dispute in this case.
Why is it disputed?
First of all, the cop says that it was 55 miles per hour. The defendant's witness says it was 55 miles per hour.
In some way, though, we know where the accident occurred, so isn't there some determinative way to know what the speed limit was where the accident occurred? Without
correct. Well,
the
police officer says it was 55 miles per hour. My client
but
says
the expert said that it was 65 miles, and he explained that he went half mile past it and saw 65, but behind it was 55. So until you get to the 65, it's 55.
The expert says 5
Whatever
miles
maybe the
before the accident occurred, it said 65. Then there's no signs regarding the speed limit until about a quarter after the accident where it says 55 miles per hour. Now, we know in New York
if I'm
State,
driving on that road, I would think it would be 65 till it changes.
well, in New York State, when the speed limit is not posted, it's automatically 55 miles per hour.
But don't you look at the last speed? If I'm driving and I see something that says 65, till I see something that says lower, I would keep going with the one that I saw.
Irrespective of that, let's say it
sorry,
was
what?
60, irrespective of whether it was 65 or 55, the client was going, the defendant was going 71 miles per hour.
That's one of the big issues in this case. If it's let me finish my question. If it's undisputed that the last speed limit that the driver would see before the accident occurred was 65, then why is there any dispute that the speed limit was 65 and not 55, which is one of your main arguments?
One of my arguments is that it's not undisputed. It is in dispute. The police officer, who's familiar with this area, says the speed limit is 55 miles per hour.
Okay, so the only evidence you have to dispute this 65 versus 55 is the police officer's testimony?
Police officer's testimony, The defendant witnessed testimony that in this area, it's 55 miles per
Okay, so
hour.
other than the police officer's testimony, which seems to be contradicted by the signs, is there any other evidence to support that it was 55 rather than 65?
Within the record, no, other than
So that
everybody's
sounds like
testimony.
what the signs actually said would override what the police officer thought.
I'm sorry, what?
Since it's undisputed that the last speeding sign anyone saw was 65 before the accident, that would seem to overcome the police
But
officer.
I would say that that is an issue of fact because the police officer who's familiar with this area says the speed limit is 55 miles per hour. The defendant in his reply says, okay, yes, it's 65 miles per hour, not 55 miles per hour based on the sign.
All right, counsel, getting back to the core issue.
Yes.
Let's accept that the defendant met its prima facie burden that the senior care was going at whatever speed it was going. Your client was on the side of the road on the shoulder and suddenly made an illegal U-turn, arguably supported by eyewitness, by the police report diagram, various other information. How did you make it an issue of fact here?
Well, we raised the issue of fact as to the speeding. We actually, it wasn't even we didn't have to raise that issue of fact. The record established it. The defendant conceded that he was going 71 miles per hour. He was going over the speed limit irrespective of whether it was 65 or 55. Okay, the evidence shows, and defendant's expert also quotes to this, that up until a half a second before this accident, defendant did not brake at all. He was going 71 miles per hour, and then a half a second before this accident, he steps on the brake. He did not turn his steering wheel until 0.8 seconds.
Defendant's counsel indicated that your expert's affidavit was thrown out.
That is false.
I didn't see that. Is that in the record?
That is not in the record, Michael. I believe that the lower court did rely on our expert report as well, an affidavit, which disputes defendant's affidavit and defendant's report, and also indicates that he took no evasive maneuvers to avoid this accident.
I mean, they did a run out in those expert reports of what was going on every second or half a second, and it seems that it took up until the last half a second for there to be any putting on of the brakes,
Correct.
Slowing down of the car.
Correct. Now,
Not enough.
the argument by defense counsel is that, well, he was faced with an emergency situation. But that only is effective and only eliminates any issue of comparative negligence if he didn't create that emergency situation. It is our argument that the record establishes that he created his own emergency situation with the speeding, with the not paying attention. He admits he doesn't even know where the plaintiff's vehicle was before the accident. He saw it 600 yards before this accident. And then all of a sudden, he admitted he doesn't know if he looked down, he didn't know if he looked away, but the witness behind him, who was apparently traveling right behind him and doing the speed limit, avoided the accident completely.
Are there any other questions? Okay, thank you very much. Thank you.
In their brief, they argue that the police report should be rejected. And now they want to rely on it. Either it has relevance or it doesn't. Their expert report, regardless, I don't believe that the lower court relied on it, but regardless, they did not submit the qualifications of the expert, and we cannot know that we can rely on any expertise because we do not know that they have it. So it's irrelevant. The emergency situation was created by a person that decided to pick up their phone while driving and stop on the road and then not pay attention and suddenly enter the roadway in an area that the speed limit is 65 miles per hour. It's just negligent. But for the driving of the plaintiff, the accident would not have happened. That's unless the court has any questions.
Thank you very much. Board of Managers versus Soho Boom Condos.
Good afternoon, Your Honors. My name is Jeffrey Metz. I represent the appellants. I'm here this afternoon asking you to reverse those portions of the court's order which refused to dismiss the second cause of action against the individual members of the sponsor, on a claim of fraudulent inducement, and the third cause of action for breach of fiduciary duty for the sponsor-controlled board members. Now, Your Honor, it's a little bit of a tongue twister, so let me just read this. I apologize. Fraudulent inducement. You must show that the alleged misrepresentation should be one of a then-present fact extraneous to the contract and involve a duty separate from or in addition to that imposed by the contract, and not merely a misrepresented intent to perform. Now, here you have a complaint, an unverified complaint, where the board, the new board, is arguing that the individuals were induced to purchase pursuant to an offering plan.
Let me interrupt for a minute, because isn't there a clear allegation in the complaint that the individual defendants knew at the time they set the common charges at the amount they did, that it was not enough to cover the operating expenses, and that they did it intentionally to defraud purchasers, even though they knew at the time that they were going to have to raise it and that it wouldn't cover it, and that they only did go ahead and raise it after the sponsors' apartments were sold. So isn't that a specific enough allegation of fraudulent intent at the time?
Actually, it's not, Your Honor. First of all, it is not extraneous to the offering plan. Everything that they're talking about.
Does the offering plan talk about what the common charges will be, and that the
Sure
common
it does.
charges?
Sure, they're budget projections, Judge. And remember something here. When you make your initial offering plan, the building is getting built. You're not, I mean, it's a projection. It's not a sworn to fact.
But weren't there allegations, and this is a motion to dismiss, right?
Correct.
So weren't there allegations in the complaint that your individual clients were told by the accountant people that it was very difficult, it was going to be a real problem if they did not, that the condo might not even exist if they didn't raise the rates because there just was not enough money? There's allegations that they were affirmatively told that, and they still did not do anything until...
Judge, there's a difference here, because that wasn't a then existing fact. That is after the fact. If you look at their complaint, they're talking about what a managing agent said years later, not at the beginning where they said they induced people to purchase based on these projections. So that does not fly. And
But they're clearly alleging that they did know at the time that it first became a condo that there was never going to be enough funds, that they were not even going to have enough to pay their bills, and they, in fact, then didn't pay bills.
Here's the difference.
I mean, there's a lot of specificity here.
Here's the difference, Judge. If you look at the order appealed from, talks about that Silver Star case. Now there, in that particular case, there was an independent engineer prior to the time that the offering plan was laid out that said there's a problem with this facade, and you should mention this in the offering plan. And the sponsor did not do that. They didn't do that, and that was found to be fraud in the inducement. That's not the same case as this case. As a matter of fact, what's the same as this case is the Alexander case, which we cite in our main brief and in a reply at pages 4 through 6. Same firm, by the way, same firm. You look very detailed allegations of all this financial impropriety. Justice Reed dismissed that because he said, as you should rule, I submit, that it's not extraneous to the offering plan. Now, very quickly, because I see my time is running, let's deal with the third cause of action. That one easily dismissed because there's no independent tortious act by the sponsor members. So on those bases, the order should be reversed. Thank you.
Good afternoon, Your Honors. May it please the Court. Your Honors, I'm just going to dive into the allegations. But here, as Your Honors well know, this is a motion to dismiss addressed to the face of the pleadings. But in opposition to that motion, we submitted a treasure trove of documentation actually proving those allegations, okay? We have a schedule of common charges for the building that the sponsor's principals swore under oath were true, even after their managing agent that they hand-selected told them over and over that the building was operating at a deficit.
Let me interrupt for a second, because one of the points that opposing counsel kept making was that these were not extraneous to the offering plan. What's your response to that specific argument?
My
was not
response to that
extraneous.
is that is irrelevant under this court's authority in the South Star, which my firm also prosecuted, by the way. As long as they're not omissions, as long as the statements are not omissions, and they're affirmative misrepresentations, which was what we have here, they are actionable for fraud in the inducement, even if they're contained in the offering plan, because the offering plan serves a dual purpose. On the one hand, it's part of a contract, the purchase agreement, it's incorporated by reference, and on the other hand, it's a prospectus to describe features of the building, so the purchasers can read the contents of that prospectus and rely on the statements in deciding whether or not to purchase their units. Even in the certifications that are contained within the offering plan are sworn by the sponsor's principals, say that. We're giving you this information, it's all true, so you can make a judgment as to what...
Representation in the offering plan that's covered by the offering plan, as long as you can show there was a present intent, and it wasn't an omission, it was a misrepresentation, that's enough to state a claim.
Correct. So, and this is not just coming from me. This is not just my argument. This is settled law in the First Department. The South Star is one of many cases we cited where this is controlling law. And just to your point, the Alexander case, which is the case on which the sponsored defendants so heavily rely, which is a trial court opinion. It's not controlling. It's not authoritative. The distinction there is the fraud allegations were, and I'm quoting the trial court opinion here, identical to the breach of contract allegations. Here, in stark contrast, our breach of contract claim is solely based on defects in the building. It has nothing to do with the common charges or the budget or anything along those lines, okay? The fraud claim, on the other hand, is based on the sponsor's strategy of understating the common charges, selling all the units, waiting to the very last unit is in contract, and then jacking them up by 65%, which is 40% higher than the threshold that's required to give a right of rescission to the purchasers. That's why they did this. If they did this earlier, by the Attorney General's regulations, they would have had to get an offer of rescission to every single contract. Everyone would have pulled their contracts and not purchased in the building, and the sponsor would have lost a lot of money. That's exactly what happened here. Don't take my word from it. Take the word of the hand-selected agent for the sponsor, who in a sworn affidavit said, the sponsor directed me not to pay expenses. We would send monthly budget projections to the sponsor.
Wasn't there a problem that they didn't pay the Con Ed bills? I mean, that went on here too?
That was one of the major expenses they told them not to pay. The building was operating at a deficit for multiple years. The auditors the sponsor hired said, we don't know if this building is going to be a going concern. Yet, all of this information was conveyed to the sponsor principals well before they sold out in this building. Okay, they continued to sell not only based on the offering plan, but amendments to the offering plan that post-dated these notifications, saying these are the common charges, they're still very low. It was only until they were in contract to sell the very last unit that they finally not only increased the common charges, but they had to make up for the budget deficit, so they issued a $500,000 assessment against all the unit owners, right? Who wasn't responsible for paying those increases at that time? The sponsor, because the sponsor has sold all of its units. What they did do is they were able to take the profits from the project, since they've sold all the units and they yielded sales proceeds, and kept them for themselves. And that's the basis for a breach of fiduciary duty claim. They have an obligation to be loyal to the unit owners, to the condominium, to do what's in their best interest, to not act in bad faith. In contrast to those legal obligations, they did what's best for the sponsor. They waited to the very last moment to increase common charges. And once they were about to sell their last unit, they did that, and they avoided the financial impact of that, whereas every other unit owner in the building had an immediate loss of about 20% in the value of their units. Thank you.
Now, there were also allegations that there was an outstanding balance, let's say about $116,000, that was about 90 days past due.
Correct.
But then it grew to more than $250,000 at the sponsor's direction not to pay. So the balance kept on increasing because of the sponsor saying, don't pay.
Correct. And it's not like the next month they updated the common charges. There were still about 15 units left to be sold during that period. So they waited again to the very last unit. Then they increased the common charges. And again, this is a pre-answer motion to dismiss. Thank you, Your Honors.
Judge, that's exactly the point. This is a pre-answer motion to dismiss. There's no findings of fact that have been made. Now, again, my adversary can't answer this question. There's two prongs to this test: present fact, extraneous to the offering plan.
So what about his response that it doesn't have to be extraneous to the offering
Because
plan?
we're
That
not-
if he can show that there's misrepresentation, that they knew at the time they were making misrepresentations, that's enough?
Because that's merely, look, that's merely an allegation, and it's not specifically pled against any of these
No,
individual.
you're making a different argument now. My question is, you keep saying it has to be extraneous to the contract. Where are you coming up with that requirement? The arguments you just responded to are
Sure,
completely
I can
different
cite you-
arguments.
I can cite you your Hawthorne case, Your Honor. It's Hawthorne Group against RRE. I can cite you to the old Hamlet case in the Second Department Appellate Division. That says, no matter how unrealistic your projections are, if it's not extraneous to the plan, it is not actionable. Now, let's deal.
Talking about the Martin Act and that? Okay.
Oh, well, no,
No,
I
time's
can-
up. Let's not get into that. We'll look
listen,
at
you
the
can't-
papers
you
and look at the
cannot hold
case.
them liable
No,
because-
counsel, it's okay. You don't need to get into the Martin Act since no one's gotten into it yet. Thank you very much.
Thank you, Judge.
People versus Haskins.
Good afternoon. Mary Catherine Smith on behalf of the Legal Aid Society. The trial court here imposed an 8-year order of protection against my client, Davinia Haskins, and failed to state the reasons on the record for doing so. The order of protection...
Counsel, before we get into the actual substance of the argument, do you want to address the waiver of appeal and the preservation arguments, which are threshold issues?
Yes, Your Honor. As to the appeal waiver, Mr. Haskins' IQ is 65, which is 5 points below the threshold for intellectual disability. His ability to comprehend verbal information specifically is in the 2nd percentile as compared to his peers. This is directly relevant to the totality of the circumstances.
What was wrong with, what should the court have done that it didn't do to have a valid waiver of appeal? Because this was a pretty thorough waiver compared to many of the ones that I've seen. So what was wrong with it?
Yes, Your Honor. The waiver is thorough, and we can see that this waiver would be adequate for someone of average intellectual.
What are you saying the court should have done different because he had less intelligence? And what cases are you using to support that argument?
Yes, Your Honor.
Well, I'm sorry, and before you even get to that, was the court even alerted to this issue? I mean, right? So that's my mind too, right?
Yes, I'll address those in turn. So as to whether or not the court was aware of the issue, the court did receive a pre-pleading memo from a psychologist who had evaluated Mr. Haskins and done intellectual testing. That memo included his IQ, it included the percentages of his verbal and reading proficiencies, which were in the lower extreme. As to what the court should have done now that it knew this information about Mr. Haskins, it could have translated that litany into something that someone with an intellectual disability can understand.
I've never seen a case that says that. Are there cases that create a different standard for appeal waivers or additional language that's required when someone's of diminished intellectual capacity?
There's not a case as to appeal waivers. We do cite to People v. Patillo, which is a case concerning a guilty plea colloquy.
Concerning a what?
Sorry, a guilty plea in that case was evaluated for voluntariness, where the defendant in that case was also
So
intellectually
you're saying whenever there's a diminished capacity, there should be a different appeal waiver than what is normally required under the law. It should be a separate standard out there, and that we should create that, basically.
I think what there should be is evidence in the record that there's actual voluntariness and knowingness in this important waiver of one's rights.
Then let's go to the, I'm sorry, go ahead.
I'm sorry. The report is also given to the defense counsel, correct?
Yes, Your Honor.
So the defense counsel was aware of the intellectual disability of his client, correct?
Yes, Your Honor.
And there's no claim of ineffective counsel here, ineffective assistance of counsel here, correct?
No, Your Honor.
So wouldn't it have behooved defense counsel to say, Your Honor, my client is a little slow in the uptake. I think we need to handle the allocution a little differently, even though the court pretty much followed the model allocution. I mean, as my colleague pointed out, it's pretty spot on in terms of its thoroughness, and you can see that. Wouldn't that have been something that defense counsel should have raised?
Your Honor, defense counsel could have raised that with the court, but it's ultimately on the court to ensure that an appeal waiver is knowing and voluntary and to be aware of those totality of the circumstances. And there are cases where appeal waivers have been overturned based on those totalities, based on a defendant's
You're asking,
experience.
you know, that kind of position you're taking, you're asking, well, from my standpoint, you're asking me to agree with you and now imposing a new burden, or at least imposing on the court the obligation to make an argument that, as my colleague's pointing out, should be raised by defense counsel. At that point, the court can then, you know, from my time in the trial courts, we're more reactive, right? We're not advocates in this. I mean, we're just not that. I mean, so it would be very difficult to take a, you know, you're just accepting your position would be us telling the trial courts, no, well, no, now you get this report, regardless of, irrespective of whether or not counsel makes any argument, you as the court have to take the lead on that. I'm not so sure. That's what I'm hearing that you're saying that we should do, or we should tell the trial courts.
Your Honor,
That's a big imposition, at least from my standpoint.
Your Honor, I understand that that can seem like a big imposition, but it is important. May I just briefly conclude? It is important for defendants to voluntarily and knowingly waive their rights and that the court ensure that.
Thank you.
Good afternoon. Again, Your Honors, may it please the court, Jonathan Sklar for the Office of Darcel D. Clark. Your Honors, before getting to the appeal waiver, the Court of Appeals has instructed the defense bar to bring these order of protection vacature requests before sentencing courts, because sentencing courts are the proper forum so that we can consult the victim, right? It undermines the entire criminal justice process, the process by which victims come forward, report crimes, with the knowledge that there will be an order of protection in place. It's not for this court or defendants to bring claims in this court to overturn orders of protection without consulting the victim.
Is this your lack of preservation argument, that there was no preservation of this issue and it was never raised below, so it couldn't have been addressed by the court below?
No, Your Honor, that is a separate point. Just a note that the defense bar continues to bring these claims in the improper forum. But you raise an excellent point. It's also unpreserved for good reason, right? They knew why the order of protection was imposed, Your Honor. A defendant acted in concert with another to rob by gunpoint the victim, and it was obvious why there was an order of protection imposed. We needed to protect the victim from the guy who tried to rob him. And this court has held numerous times that when it's clear on the record, the court does not have to state the reasons on the record because it would be superfluous. As to the mental illness point, Your Honors raise an excellent point, right? Defense counsel, when defendants signed the waiver, defense counsel acknowledged that the waiver had been signed, did not notify the court, alert the court that defendant may not understand the appeal waiver. In fact, he said as he said, yes, I understand. Defense counsel never said, Your Honors, maybe he doesn't understand, maybe he's just saying he understands. Also, it's a completely disingenuous claim when defendant is not trying to, is not saying that he didn't understand the guilty plea. How could his IQ be such that he doesn't understand the appeal waiver but understands the intricacies of the guilty plea just fine? That doesn't make sense. If Your Honors have no further questions, we ask that you affirm. Thank you.
Thank you.
Counsel, I do have a question because you mentioned Patillo, and I'd like to know why you believe that case is controlling. And the reason why I ask that is because, unlike Patillo, in this case, I believe that the court confirmed at least 2 times, it could have been 3, confirming that defendant read the waiver, he discussed it with counsel, confirmed at least, I think, twice that defendant understood what was being explained. Defendant was not forced to sign the appeal waiver, and that counsel answered any questions that defendant had. So we have that here. Patillo was totally different. So why is that controlling here? Because it's so different.
Your Honor, Patillo is persuasive in this case, mainly in its discussion of the ways in which intellectually disabled people may present in court and may feign understanding of the proceedings before them in an effort to mask their disability.
Thank you very much. Newman versus New York City Housing Authority.
Good afternoon. May it please the court. My name is John Paszewski of Hannum Pertic, Prendergast, and Merlino, and we represent the third-party defendant, appellant, respondent, Triple H Construction in this matter. Here, the trial court improperly denied our motion for summary judgment to dismiss the third-party claims against our client, and specifically the remaining claim at issue here for contractual indemnity by the defendant, third-party plaintiff, respondent, appellant, New York City Housing Authority, or NYCHA. The evidence the trial court clearly discussed in the underlying order demonstrates that the condition plaintiff complains of here that caused his accident was caused solely by NYCHA and its employee in either spilling fluid.
Let me ask.
I was going to say, is it premature that we're making this determination about whether there could possibly be any negligence when that hasn't been decided in the underlying case yet?
So I believe that the court did decide it in the underlying case, Your Honor, but then reached an erroneous conclusion based upon its findings throughout the order. Specifically, the court states in the underlying order.
Yeah, it's at page 8, right?
There's things on page 6, page 8.
Where it kind of seems like you're not negligent, but how did it reach its earlier decision saying that you're still
multiple
there, right?
findings. To the extent NYCHA is found negligent, it can't be indemnified. On page 8, as you mentioned, record 15, even if workers' compensation law did not apply, there's no evidence Triple H was negligent in any manner. The accident arose from the...
Let me ask a more focused question. Let's assume there's no evidence that you are negligent and you have no duty to warn because you're not a building owner, you clearly didn't cause the spill, so there's no negligence.
Correct.
So then you have to go look to the language of the policy and what triggers it. And it appears that the language here is extremely broad indemnification clause, that it doesn't have a negligence trigger, that it arises out of any act. So how does that play into the analysis then?
That's correct. And on page 9 of the order, the court specifically says, after discussing that indemnification provision, setting it out in the order, here, Newman's claim does not arise from the work being performed, demolition of the interior staircases, nor any negligence on Triple H's part.
Well, why doesn't it arise from the work being performed? Because it was your worker who was injured while he was performing his work. And I think there's a number of cases where we've held that if you're injured, you, the employee, are injured while you're performing your work. Even though there's no negligence, it arises out of your work because you're working and you're injured. So why wouldn't that trigger the indemnification clause?
Because at that point, the only negligence remaining can be NYCHA's negligence. It caused and created the condition.
So let me ask you a question. So then that gets you out under the anti-subrogation. So let's get even more nuanced and break out costs and expenses versus bodily injury. So I assume your argument is even if the indemnification clause is triggered, there's no liability for bodily injury because the only negligence that could be here is the negligence of NYCHA, and they can't be indemnified for their own negligence. What about the costs and expenses, which aren't covered by the anti-subrogation rule?
That would still be indemnity, though, Your Honor, and they could not be indemnified for that if the accident was caused and created by their actions, their
Don't
negligence.
we have some authority in the First Department where a distinction is made between bodily injury and costs and expenses, and that even though you couldn't be indemnified for bodily injury because it's anti-subrogation, you can be indemnified for costs and expenses under an indemnification clause.
So under this provision that we're dealing with, even as you said, if it's triggered because he was an employee, I believe that the exception here still applies, that they cannot be indemnified based on the language in this provision for the defense that's stated in the provision, the indemnity of defense, which is, I guess, the costs and expenses you'd be referring to.
Why can't they be indemnified?
Because again, they own the building, they were responsible for maintaining the building.
That's the
They put that-
anti-subrogation. Okay, I asked the
Well,
question. Okay,
sorry,
let me
yeah.
hear from opposing counsel. and then we'll-
Sure, thank you, Your Honor.
Hi. Good afternoon, Your Honors. Gretchen Becht, Newman, Myers, Cranes, Harris for respondent, appellant, NYCHA. The case that you're referring to, that we are entitled to defense costs, even if there's no finding of liability, that's DeParna in 1994, I believe it is. So we are definitely entitled to defense costs pursuant.
Why
It's just
should
triggered
there
by
be-
claims.
Why should there be a distinction between recovery for bodily injury, which would be precluded because it would only be arising from your own negligence, and costs and expenses?
Why should there be?
Why should there be that distinction?
Well, just by contractual language. This is a purely contractual interpretation. It's a matter of law. I'm arguing for that should be decided by the court, and that the judge should have decided rather than saying there was an issue of fact as to whether the clause was triggered. I'm saying that's a matter of law for the court to decide
And why
whether
is
the
the
clause.
clause triggered?
It's triggered, obviously triggered, because it arose out of, the accident resulted directly or indirectly for his work for Triple H. He was there because he was working for Triple H. He wouldn't have been there if he wasn't working there. The accident would have happened if he wasn't working for Triple H. So it clearly arose out of his work for Triple H. Also, the clause is triggered for any reason whatsoever, and counsel did not say that that was improperly broad.
Are you conceding that there can't be any indemnification for bodily injury because the only negligence that would arise is the negligence of NYCHA?
No, not at all. I think it's clearly an issue of fact as to whether, I think the court got it right. There was an issue of fact as to whether Triple H was negligent.
Why?
Because
what
he,
evidence is there of
there's
Triple
plenty
H?
of evidence that Mr. Lorenzo, the supervisor, if you look at the contract, they were required to immediately clean up any spill, any wet condition, any dangerous condition on that floor. They were required to clean it up. He saw the wet condition twice and did nothing about it. He just assumed that this woman, Mimi, who we don't even, never even testified, would clean it up. So that is negligent in itself. He saw the condition twice. He never warned plaintiff or any of the other.
Why? Normally, the duty to warn is as against the building owner, not as against a worker, a construction person in the building. They don't normally have an independent duty to warn.
It's a basic negligence principle of carelessness.
Right, but normally to have a duty to warn, you either have to have created the condition or have some duty based on who you are to warn. Obviously,
I
Triple
think
H didn't create the condition, so where does that duty to warn arise from?
Well, I'm arguing that there is issue of fact as to whether Triple H created the condition, because that was not undisputed. There is
What evidence is there that they ever used any liquids?
Mr. Lorenzo. They could find this testimony to be incredible because he never mentioned this Mimi woman in the statement to NYCHA, and he was on the floor himself. It was his workers on the floor doing the work. So, and they were using water to do their work, and he had access to the slop sink where apparently Mimi, they claim Mimi went into when this spill occurred. So I think there is enough evidence to connect the dots to say Triple H may have caused the spill. In fact, Mr. Muhammad said he thought Mimi, he didn't even know who Mimi worked for, and he said, I think she worked over there, meaning who's working over there? Triple H. Triple H was the only people working over there. I think Triple H caused the spill.
Okay, thank you very much.
Thank you.
So we did addressed Deperna on, I think, page 9 and 10 of our reply brief. And again, splitting hairs, the costs and expenses versus the indemnification of anything that NYCHA would have to pay to plaintiff is just that, splitting hairs. They can't be.
But if the only reason, I guess this was a question I was asking for, the reason that you wouldn't have to indemnify, if the indemnification clause is construed because he was working when it happened to cover this, the reason why Triple H wouldn't have to give contractual indemnity for bodily injury is because of the anti-subrogation rule. So I guess the question is whether that anti-subrogation rule also, you can't be indemnified for your own negligence, also applies to costs and expenses, or whether it's a different analysis.
I mean, I think under general obligations law, it would, Your Honor.
Why? But
Because
I think we have a case to the contrary. That's why I'm asking.
Right, and I think that was what we had just mentioned, Deperna, which is addressed in our brief. And the fact that NYCHA would be enriched by getting back defense costs for something that they, created, caused.
I mean, but that's contractual. I mean, that's the way it goes, right? When you enter into a contractual indemnification, right?
Right, but that's a void against public policy under General Obligations Law 5-322.1.
Are you familiar with Ging versus F.J. Sciami, which is the case that I've been referring to?
Excuse me, which one is that, Your Honor?
Ging from the First Department.
I am not.
Okay, that's the case that talks about costs and expenses being different, but okay.
Okay. Well, regardless, touching on what counsel mentioned about Triple H, questions about Triple H's negligence, it's just not the facts of this case. The testimony is very clear. Mimi spilled something. Mimi mopped it up. NYCHA says, we put up warning signs. Even my client said the same thing. And so, there's no dispute between us about that. And
Thank you.
this could only have been from NYCHA's negligence.
Go ahead. You have 2 minutes.
Sorry, I missed that. Yeah, I would say that if there was no finding of liability, there would be no violation of the general obligations law because there would be no finding of liability against either party. And according to Department, there still would be.
Say that again?
If there was no finding of liability as to either NYCHA or Triple H, there would be no violation of the general obligations.
To indemnify because.
No, according to Department, they still would be entitled to defense costs because just the claim triggered it. So there would be no violation. They didn't catch the last part of what he said about Mimi, but if you just read the reply brief that I said, I think there is a question of fact as to who Mimi worked for. No one actually said that she worked for NYCHA, was never admitted, and there's an issue of fact as to who caused the spill.
Thank you. People versus Agilar.
May it please the court, Samuel Steinbach-Pratt from the Office of the Appellate Defender on behalf of Oscar Agilar. It is long settled law that the people are not ready for trial when they have failed to produce an incarcerated defendant. Because it's undisputed that the people had not produced Mr. Agilar from ICE custody as of November 28, 2018, the notice of readiness filed on that date was necessarily illusory. And because the notice of readiness was the only basis the court below relied on to exclude the majority of that adjournment from the speedy trial calculation, it erred. When the remainder of that period is added to the time already properly charged by the court below, the people substantially exceeded their allotted time under 3030. Mr. Aguilar's conviction should be reversed and the indictment dismissed. Respondents' only serious attempt to grapple with this longstanding rule, which this court has stated in Brewer, in Daniels, the Court of Appeals has stated time and again, is to rely on a stray out-of-context sentence from People v. Carter. But Carter arises in an entirely distinguishable context. There, the issue was the defendant's arraignment of a non-incarcerated defendant, and as the court pointed out, arraignment is a court responsibility and therefore does not implicate the people's readiness to proceed. In contrast, the production of an incarcerated defendant is the responsibility of the people. And their failure to abide by that responsibility means they're not ready for trial. Of course, there's any number of actions that people could have taken to ensure that Mr. Agilar was produced in a timely fashion, but they didn't take those options, and having failed to avail themselves of those at the time.
Your position is that the defendant should have been, so November 14th comes, right? So the people are not ready because the ADA that's supposed to be trying the case is on trial. They adjourn it to November 28th. The position you take then is that the defendant should have been produced on November 28th because the people said that's the day they're ready, right? And if he were produced on that day, you wouldn't have this issue, because now what happens is he's not produced until January 15,
Yes.
48 days later.
Yes.
So that's why you're saying that the November 28th adjourned date was illusory. It didn't really, so that the entire 62 days, 14 days from the 14th to the 28th, has to be included to the 48, which gets you over the 30-30.
Correct, Your Honor. One option would have been to have him produced on November 28th and advance it for the purpose of taking him into custody, which is actually what the people said they were going to do on November 14th. They said, we'll arrange to have him produced whenever the assignment's trial is over, and that's the date we'll state ready. For whatever reason, they don't end up doing that. I would also note that, when they say they're ready on November 28th, because they haven't actually produced him, at most what they can say is, well, we think he'll be produced on January 15th and we'll be ready then. But the Court of Appeals has been quite clear that an expectation of future readiness is of no effect in the 30-30 context. They have to actually be ready on the date that they say they're ready.
My understanding is that the attorney who was going to try the case was ready on November 28th. The issue was producing your client from ICE.
Well,
you've not claimed that the affirmation of the ADA who came in on the 28th, who had originally been involved with the prior trial, made a false statement on the 28th by saying she was ready when she wasn't. I believe that's undisputed.
I don't think it was a false statement. I think it was legally incorrect because as a matter of law, she could not actually be ready without having produced Mr. Agilar, because that's the rule laid down by this court and the Court of Appeals. So as a matter of law, whatever preparation she'd done just didn't make her ready because he had never been produced.
If I'm hearing your argument then, that SRO, that's statement of readiness, has to be coupled with a production of the defendant on that day. Otherwise, if the defendant's not produced, is not appearing on that day, then automatically it's illusory that the time when they asked for the adjournment or had the court adjourn it, that's all, that as my colleague was saying, that was all, fabricated. It wasn't actual. Is that what you're saying, that you need to produce the defendant on the day, on the new adjourn date?
I think that's the necessary consequence.
Is that practical? So, I mean, sometimes it's out of the people's control as to whether or not DOC actually produces the defendant.
Well, I'll say a couple things about that, Your Honor. The first,
in this case, wasn't there like an ICE situation, or there was a deportation issue going on?
The reason he was taken into custody, yes. I mean, the difficulties arose on that end arose later, but what I would say is a couple things. First of all, I think it's the necessary consequence of the rule that the people can't be ready until the defendant has been produced, that they just can't state ready off calendar without having the defendant produced. I would also note, it doesn't seem like this issue comes up a lot. In my research, I was unable to find a single case where any court in this state has recognized.
Right. So that if I were to agree with you, just speaking for myself, that would mean that every time that the people pick a date that they're saying they're ready for trial, that the defendant has to be there also. Otherwise, if the defendant's not there, the people have now just put themselves in harm's way as to whether or not there's a 30-30 violation. I'm not so sure that that's something that I could agree to.
No, Your Honor. I want to clarify that's not the rule that we're.
Okay, because that sounds like what you want.
That's what I heard too.
That's what I heard.
The people have to have produced the defendant before they declare ready. He doesn't need to. I mean, and what we understand produced to mean in the context of the case law is lodged in the custody of the Department of Correction, right? So he doesn't necessarily need to be produced in court on that day. Right. If he's been produced previously, he doesn't necessarily need to be reproduced every single time. The issue here, and I do think this is an exceptional case that's not likely to recur often, is that he was never produced from ICE custody at any point before this statement of readiness.
Thank you.
Thank you.
Okay, please.
Good afternoon, Your Honors. Noah J. Sexton for the people. Your Honors, the standard that defendant is proposing today would functionally render off-calendar statements of readiness obsolete. It
Not
would
only
mean
obsolete, impossible.
it would render them impossible. At the end of the day, in the context of statements of readiness, 3030 is concerned with the people's
Right, this all goes to what the people represents to the court when they're ready to go.
Absolutely.
In terms of third-party participations, I can't control third-party participation, right?
Absolutely, and if you look at the time that this happened, working with ICE was necessarily complicated. I would point out, too, that 3030 is focused on impediments that are, attributable to the people. At this point, ADA McHale, she was done with trial. We had filed a proper written order to produce. We had secured transportation through our detective investigators. All the impediments that were attributable to us were gone. We were ready to go. This is further evinced by the fact that at the next court date, he was produced. He was there.
January 15th.
January 15th, yes, and that delay to January 15th is ultimately because that's when the
I
court
don't think
gave
there's
us.
anything in the record that demonstrated that on November 28th or leading up to November 28th that the people had anything to do with the fact that the defendant wasn't produced on the 28th.
Absolutely. This is
I think I saw that in the record.
pretty much every time that he was not produced by ICE, it was either due to a personnel issue or even early on where we weren't 100% sure where he was even. We eventually found out that he was being held in Bergen County Jail.
So just picking up what your colleague said, the case law in this department doesn't mandate that the SOR has to be backed up with the production of the defendant when that statement is made.
It doesn't. And even my adversary claims that we rely on Carter to say that that is not required. Okay, let's throw Carter out the window. It doesn't exist. We have People v. Camillo, in which this court held the people are not required to produce a defendant instantaneously upon the filing of an off-calendar statement of readiness. It's as simple as that. Filing an off-calendar statement of readiness and needing to produce the defendant every single time, yes, in theory we could advance it, but at that point, you're putting the burden on the people to advance a case when that requires at least two other people working with us, the consent of defense counsel and the court being able to indulge that request, which doesn't always happen. A good example of that on March 1st, 2019, which was after all this.
I'm gathering from the argument is that the contention that it was illusory, that November 28th was illusory, is bootstrapped or based on the fact that the defendant wasn't produced on that date. That's how they're going to be able to challenge this, right?
That is essentially what this entire argument is about, because if that statement of readiness is not illusory, which we assert that it was a totally valid statement of readiness, that's it. We were within the 30-30 time frame. And the only way that you can really...
Well, to agree with that would mean that it would go out the door in terms of your representation, because it's always, the 30-30 is always based on the people's representation. It's got to be accurate, it's got to be bona fide, but to agree with what was being argued here would now throw all that out the window, because it doesn't matter if it's bona fide and if it's accurate. If you don't produce a defendant, it's automatically illusory.
Exactly. It creates...
So it doesn't matter what you say at that point.
It creates an unworkable rule. It totally goes against the fact that we are entitled to a presumption of validity in our statements of readiness. There was simply no reason to believe that this was anything other than a good faith, accurate statement of readiness off calendar. And so for those reasons, unless your honors have any other questions, we would ask you affirm.
Thank you.
Thank you.
I'd like to just make clear that this is a pretty narrow situation because it only applies in the context of a defendant who is in...
Counsel, it's a narrow situation, but if I were to agree with you, it would have serious ramifications, okay? Because at this point then, if I were to agree with you, it would basically say that whatever the people say in terms of representing to the court, that they're going to be ready at the next adjourned date, doesn't matter, because if the defendant's not produced on that date, it's automatically deemed illusory. And that therefore they violated the 30-30 rule, the speedy trial rule. Well, I mean, you may say this is narrow, doesn't happen oftentimes, but if a decision like this comes down, that would have some severe ramifications going forward.
Sure. So, I mean, this court has said in Daniels, in Brewer, the Court of Appeals has said in England, just this year in Labate, they reiterated it. Until the defendant has been produced, if they're incarcerated in another jurisdiction, the people are not ready to proceed. That rule has been stated time and time again. We cite all the cases in our briefs. And because Mr. Agilar wasn't produced by this date, they couldn't be ready. They could have produced him sooner. They could have produced him on the day, but they had to produce him. Thank you.
Thank you very much. Rockefeller versus Etna. Go ahead.
Good afternoon, Your Honors, and may it please the Court. This is an insurance dispute between large, highly sophisticated entities over the rights to coverage under what the Court can see for itself in the Joint Record on Appeal are highly complex, high-value, bespoke business insurance policies with more than a dozen different coverage parts, many endorsements, and in-term amendments, all tailored specifically to Rockefeller's insured coverage needs. The complaint asserts a claim for breach of those contracts, which we do not challenge at this threshold stage. That claim for ordinary contract damages from the breach includes essentially penal prejudgment interest that will more than compensate for the lost time value of the money that Rockefeller claims it is currently owed. But we do challenge the other two claims, Your Honors. As I'll detail in the second part of this argument, General Business Law 349, the claim under 349, fails because it does not allege consumer-oriented conduct, as that phrase has been construed and applied in cases like NYU, which is essentially the same case and its progeny.
No, it's funny, because one of the things you said is this is a unique, unusual insurance policy, and that was the case in NYU. That was a very unique policy. NYU really dictated a lot of special terms that was not typical, and they had a directive insurance. What evidence there in this case, although I think it's a pleading, that this is not just a typical business insurance policy that many businesses get typically, so that it would fit under the consumer-oriented?
Right, so it is a pleading, but the pleading, of course, incorporates the policies that it's based on, and you can just look at the policies. I invite you to do so. I'll direct you right now to pages 118 and 119, which are the beginning, the first 2 pages of the INA 1972 policy. I'll hold it up. It's a handwritten index, handwritten notes about what is in this policy. Then you start flipping through the policy, Your Honors. The whole thing, it's forms, because as you know, business insurance is sort of based on forms, but then you take the forms and you type in specifics,
But
you
why,
write
why
in.
isn't this what about this is not a typical policy for an institution such as Rockefeller?
This is what I'm saying. There is no such thing as a typical policy. The policies are always written with specific needs, with endorsements, right? That you have a basic coverage grant, and then here there's like dozens of endorsements, dozens of different coverages with different components that are covered, different amounts that are covered, different exclusions. There's amendments during the term of the contract. Things are written into the contract. You don't know if that happened down the street or not, or anywhere else. And it's an amendment to.
We don't know because we haven't gotten into discovery yet. This is a pleading motion.
No, but on its face, what I'm saying is it is a specific, unique policy. Just look at the policy and you'll see just how unique it is. There's handwritten notes all over them. All over them. The policies they're almost 100 pages long, very detailed, very unique, as business
You're
policies
asking us
are.
to find as a matter of law without having any testimony, expert evidence, et cetera, to make that finding at this point.
Well, I don't think it's a finding. It's just the basic premise that consumer-oriented conduct has to be based on a consumer product. This isn't a consumer product. On its face, it's not. It's purchased by a broker. It involves the involvement of a broker to get the policy, which consumers don't have. Cases like Himmelstein.
Isn't it a standard form that everybody uses? Everybody sees?
Right, exactly not.
It's not.
No, it's far from it. It's like 100, as I was just saying, it's like 100 pages long with all kinds of endorsements, and where there are forms for sure that say here's an endorsement, but then the form it's just blank, and then you type in the details under that form. There's a page in the INA policy that says see attached folder for details.
Hold on. So when you say the form, there are certain provisions that are standard that are being used. You have endorsement. I understand there is endorsements, there are declarations, they're specific to policyholders and what they want. But for the most part, you're not rewriting this policy over and over for every new policyholder. You have a standard form that you use that you either add stuff to or you subtract stuff to, correct?
Well,
I mean, this is
but add stuff and subtract to it, that's the whole ballgame. That's what you do, is decide through endorsements and exclusions and various.
When I'm getting these insurance disputes, I'm looking at every page, not just the exclusions and not just the.
I know, what I'm talking about is every page, almost every page of the 100-page of this policy, please look at it. There's typewritten notes that are entered in for this insured to describe what this insured is going to get because of this insured's needs that wouldn't apply to the next insured. Just on their face, they wouldn't apply.
Okay, let's cut to the chase here. So, you're saying that the breach of contract and the implied covenant claims, they're duplicative. But, when you go to the complaint, the breach of contract focuses on the failure to defend and pay. But then when we go to the other cause of action, it's something a little different. And now we're talking about certain actions that were done to frustrate the purpose of the policy. Like, for example, unjustified delays, refusing to settle, protracted discovery. So if we're taking this, how is that duplicative?
So there's two problems with the duplicative nature. One is that it's required that you assert damages, harms that are distinct from the simple failure to pay, right? And there are no damages alleged that are distinct from the failure to pay. Bioeconomy sets that basic rule. You have to have special consequential damages, and this court applied it in DK Properties, and both of those cases are good examples of what that rule means. In bioeconomy, it was a business interruption policy, and there have been delays in providing for business interruption, and as a result, the insured lost more business than was covered.
Right, but here they're making claims that as a result of having to settle all these cases without having the insurance proceeds, they had to go into their endowment for a substantial amount of money. They lost the ability to use that money from the endowment that they could have otherwise used. They allege a number of things.
So,
and then we found out
had to pay a lot of defense costs and other expenses that were over and above just not getting the policy amount.
So 2 points on that.
If I may, and I'm sorry I cut you off, Justice Kern, I apologize, I interrupted. But I wanted to say something, but wouldn't we find it out in discovery about what the damages are? I mean, this is just a pleading stage.
Right. So, I mean, it is the pleading stage, but the 2 points are none of what Your Honor just mentioned are in the complaint. So it's not in the pleading stage. I take the point that it's the pleading stage, but all they complete in the complaint is consequential damages. And this court just said in DK Property that the DK Property complaint fulfilled the pleading standard, quote, by specifying the types of consequential damages claimed. They don't specify the types of consequential damages claimed. In DK Property, the court said there were specific categories identified, and that's all they had to do.
If that's really true, you're allowed to amplify your pleadings anyway.
I'm sorry?
You're allowed to amplify pleadings if they're deficient.
Well, I mean, they would have to amend it to identify the specific categories that they're claiming so that we can then test them at the threshold. And the problem they have there is, my second answer to what the litany Your Honor just identified, which they identify in their brief, not in the complaint, is that all of those are intrinsically tied to just the lack of money. They're not consequential damages. They don't show or allege or say anything about how they caused an independent monetary loss to the entity. They're just not having money, which is fully compensated already by the prejudgment interest they would win if they establish that there was a breach of the contract, which is why this comes back to breach of contract, by failing to pay. That's what this ultimately is about. Thank you, Your Honor.
Let's do I'm sorry, introduce yourself first.
Good afternoon, Your Honors. Natasha Romagnoli on behalf of plaintiff respondent, the Rockefeller University.
What about the argument that you haven't sufficiently alleged those special damages in your complaint?
So I would direct Your Honors to paragraphs 8, 31, and 139. There are allegations, and let's remember, this is a notice pleading standard right now. There are allegations in our complaint that the reason that the university purchased these insurance policies, and let's be clear, it's not one 100-page insurance policy. It's roughly 40 years of insurance policies. The university purchased these policies to protect itself as a nonprofit institution whose main source of funding is its endowment. So when Mr. Hacker stands up here and says, we haven't explained what consequential damages are, I take issue with that because there are explicit allegations in our complaint that must be taken as true on a 3211 motion that say this. When we had to pay over the course of the past 6 years 1,100 settlements, over $700 million, that when we are a nonprofit who's not set up to pay claims and we have to tap into an endowment, which anybody who understands how nonprofits and endowments work would understand that an endowment typically, right, has long-term investments, sometimes in perpetuity, that are meant to be a liquid. That's how endowments protect against the volatility of a market. So when all of a sudden you're a nonprofit institution, and I'll take issue later with him describing us as a very sophisticated entity on par with Travelers and Chubb, and we have to find a way to squeeze money to pay over $700 million, we get a reasonable
Let me ask you a
inference.
question. All right. When did you first submit your claim to the insurance carrier?
In October of 2018, the claims started rolling in then.
The claim started rolling in. So in my mind, and I'm thinking of this, is that, based on your allegations, is basically they're stringing you along. Let's wait and see, and you're paying out, what'd you say, $700 million in claims, right? I don't know. Why didn't you, and I guess I didn't have a chance to ask your colleague here, but the declaratory judgment action should have came down quick, right? If they didn't want to pay you, that's the way to do it, right? Instead of letting you having to deal with all this stuff, yes?
Why did they not file a
Yeah,
declaratory
I mean,
judgment action?
that's the answer that they could answer, but I would think that's where that would go, right? Instead of you having to bear all this incredible.
That doesn't serve weight.
Well, we would still, I mean, the problem is, right, we are not set up as a nonprofit to sustain, nobody expected.
I mean, this is a case you started in 2019, and we're still in the pleading stage 5 years later.
That's actually, well, we're in the pleading stage because of this motion to dismiss, but the reality is, as you can imagine, we are well into discovery now. So we have had things like document productions where we have produced documents showing our consequential damages. We have had interrogatories where we identify people.
So that isn't that laid out in your second amended complaint and some of the affidavits and things that have been submitted here? What those consequential, I mean, we figured it out. I'm sure they could have figured it out.
Well, and I note that, right, I mean, Justice Kern, you mentioned an endowment as well, having noted in our record that we mentioned the endowment. So our amended complaint was
major components of your separate damages.
correct. And also, right, obviously, when Justice Kennedy, when you mentioned that this is the type of thing that we are able to find out in discovery, that we're able to, Justice Kern, I think you said, amplify our pleadings. That's already started to happen. I don't want to go beyond the record, but look, not only do we get an inference, right, that when $700 million, a nonprofit has to find a way to fund that, right? An endowment isn't a piggy bank. It isn't just something that you can go into and you have $700 million sitting around for.
Let me go back to a statement made by counsel that this case should be, especially to the GBL, should be controlled by the NYU case. If these policies are so distinctive and complicated and are not ordinary policies, what's your response to that?
So my response is, that's great that we've had a preview of their summary judgment argument and what they hope their experts are going to say about our policies, but that isn't anything that, what he has said, none of it can be considered here on a motion to dismiss. The difference in NYU was this. NYU, in their case, pled that they had a manuscripted policy. So you had a policyholder standing up in front of the Court of Appeals acknowledging in their own pleading that it was a manuscripted policy. Now, I don't know how much experience Mr. Hacker has with insurance policies, but I'll tell you this. Just because you have, what did he say, lots of endorsements and lots of exclusions and some handwriting on it does not make for a manuscripted policy. Those policies, we have dozens and dozens of them. And by the way, part of the reason we don't have all of them is because our bad faith claim rests in part on their violation of DFS guidance at the time that the CVA claims started coming in saying, insurance companies, obviously people are going to have a hard time finding their policies. Don't jam them up by telling them, as they have done, we don't even know if we're your insurer and we won't help you look for your policies. And when you give us secondary evidence and you give us partial policies, we're going to ignore you for years and not tell you if you actually have coverage with us. So it's rich for him to stand up here with whatever one single policy he has grabbed and put in front of you and opine as if he is an expert himself and we are somehow at summary judgment stage or at trial and say that those policies are manuscripted. Our complaint alleges over and over again, and it has to be taken as true, that these are standard form policies that were issued to other nonprofits, other educational institutions, and other hospitals who, like us, also face these claims. We further allege in our complaint, which is never...
I'm sorry. So again, you're leading into what I want to ask now. So as to the fifth cause of action, essentially, you're the equivalent of consumers.
We are consumers, absolutely.
And therefore, their deceptive practices, as alleged with respect to the strategy of wait and see, which costs you $700 million as of now, could similarly affect hospitals who are subject to these kinds of lawsuits, other educational institutions. Fair?
Yes, absolutely. And we allege specifically how we believe that this is affecting other policyholders with these type of standard form policies who also face CVA claims. Because there's a game afoot here with what they are doing. Remember, 349 was passed by the legislature to deputize individual consumers, whether it's an individual as a person or a company, to act as a private deputy attorney general. And that's exactly what's going on here. Rockefeller has been able to, at great expense to itself and harm, we allege how it's actually been brought to its knees because of this situation, but it is here arguing for its rights and on behalf of other policyholders, because these standard form policies, as we've alleged in the complaint, are issued to much smaller institutions, to nursery schools, to secondary schools, to other nonprofits, to other colleges, who, and we allege this specifically in our complaint and it's never addressed, the insurance companies figured out a game with these CVA claims, much like they have done in the past with asbestos and other types of mass tort claims, where they say, we will delay, we won't investigate, we won't acknowledge your policies, we will, in this case, 6 years, not pay a single dollar, not $1, to any settlement. Travelers hasn't paid a single dollar to any defense costs. And if you, policyholder, want to fight us, you are going to take on what? At this point, we are running into half a decade of litigation to try to have our rights vindicated. So if this is not an implied duty of good faith and fair dealing claim, if this is not a 349 claim, I don't know what is, Your Honors.
Thank you very much.
Thank you, Your Honors. Under 349, there's not one case anywhere involving business insurance policies. All the insurance policies are consumer policies that are off the shelf and they're the same for everybody. I accept that point. There shouldn't be this case because—
How do you address Himmelstein? How do you address the holding in Himmelstein?
Himmelstein proves my point, because that case, yes, you can be a business as a consumer, but that was law books that were the same for everybody. Every single person who purchased a law book was purchasing the same law book, and they were all deceived, or none of them were.
That businesses can use the GBL provision.
100%. I'm not disputing that. I'm saying businesses can't use the GBL provision when they're talking about an individualized relationship, which is exactly what the 40 years of policy shows. I'm not talking about one policy. That's exemplary. Look at the policies, Your Honor. Your Honors, they're incredibly detailed. 40 years of—
If we look at just their policies, of course they're going to be able to, back up what you're saying. We have to look. I mean, there's got to be discovery and see what the other not-for-profits, the other nursery schools, the other hospital, what kind of policies. If they have similar policies that the plaintiff has here, guess what?
I disagree with the premise, Your Honor, because we're not talking about— they're not going to be uniform. You don't need discovery to know that. Just look at how detailed these are, and you know that similar isn't enough when you're talking about sophisticated business transactions.
I don't know. We don't know yet. That's what discovery is all about, right?
Thank you very much.
Thank you, Your Honors.
Sorry, do you have another question? Okay. Windmar Properties versus City of New York. Come on up.
Thank you. Lower this a little bit. Good afternoon, Your Honors. Maya Petrocelli for Appellant Windmar Properties, LLC. This appeal stems from the improper dismissal of an Article 78 proceeding that challenged the denial by oath of a number of motions that were filed by Windmar to vacate defaults at oath hearings. Now, there are two grounds on this appeal. The first is based on the simple principle of stare decisis. While that principle has taken some hits over the last year based on the Supreme Court rulings that have come down, it's still—
Stare decisis, the analysis that we're talking about here, we're not talking about court rulings, we're talking about administrative agencies, isn't it a somewhat different analysis?
So matter of Charles—
A different standard as to how it's to be applied?
Yeah, so matter of Charles Field Delivery is a Court of Appeals case, which expressly said, like the courts, administrative agencies have the obligation, when faced with similar facts, they have to issue similar rulings.
Well, it really depends. I mean, what's unique here is you happen to have been the attorney that handled a number of these groups of summonses, not only for the Windermere entity, but for other similar situated building owners. So you drew on your own experience. What becomes important is how you manage to vacate the default. Now, the traditional rules of vacating a default are somewhat similar even in our courts, and they usually are time-based or time-sensitive. So let's take the easier issue. The easier issue is you claim that the fines imposed are punitive. That's the second issue you point out. I'm doing that first because that's easier to me.
Okay.
So, but it seemed clear from the case law that it's not designed to be punitive. It's designed to be remedial. It's designed to ensure compliance, that your clients show up for the hearings. And when it's designed that way, then you can't have a claim of excessive fines under the Eighth Amendment. That's point one. But let me finish. But we also know that you weren't stuck with them. In other words, if you got a default notice and you answered within a certain period of time, I think it was 70 days. I mean, I didn't memorize the rules here. They have enough rules here. But if you met certain timetables seeking to vacate the default with an excuse, and I'm not questioning the excuse in the context of prior counsel representing your client and the other building owners, unfortunately, because of sickness, the balls were dropped. We understand that. The question is with each particular type of case, was an appropriate record made seeking to vacate the default, and was it done in a timely manner? It's not cookie cutters here. It can't be. So how do you respond to that?
Is your question regarding precedent or excessive fines?
Well, the first point is, do you recognize, you take issue with the fact that it's remedial, you claim it's punitive, correct?
So one, in terms of the excessive fines argument, in the denial decisions, there is absolutely no response to the constitutional arguments that were raised in the motions that were filed before oath. So to the extent that that is outside of the record, all of respondents' arguments are entirely improper, and the court should not have considered them. If your honors look at the denial decisions, there's no constitutional anything that is mentioned. And to the extent that there are certain cases, including matter of James v. SLA, which specifically states that a party, when they file a motion before an administrative agency, has an obligation to raise constitutional issues. And if they don't, that issue is waived in the future Article 78. So if a party who files a motion has that obligation, then respondent should have that same obligation to respond. The failure to do so is by definition arbitrary and capricious. Now separately, turning to substance, the default penalties are 5 times the base fine. Now, the DOB and respondents have already figured out all of this. The base fine is related to the egregiousness of the violation. Class 1s are more expensive, Class 2s are less expensive. We're not arguing that. If a building owner continuously fails to correct a condition and they get subsequent violations for the same condition, there are aggravated penalties that go up. We're not disputing that. However, the default fine, which is 5 times the base penalty, is literally solely a result of not appearing in court. If we analogize it to the Supreme Court, if I enter into a contract with counsel wherein I lend her $100,000, she doesn't pay it, I file a breach of contract action, she doesn't appear, she defaults, a default judgment is issued, that would be akin to the default judgment saying she owes, instead of owing $100,000, she now all of a sudden owes $500,000 because she didn't appear in court and she didn't avail herself of the opportunity to defend herself. That makes no sense. The respondents have already figured out ways to associate fines with the egregiousness of the violation and the continued violations. And what's important to note is that excessive fines, constitutional argument applies unless the sole purpose of the fine is found to be remedial. Even if there's some argument that could be made that the default fines motivate someone to appear in a hearing, that's not 100% remedial. It can't be. And quite frankly, the failure to appear at a hearing only benefits Oath and the DOB, because all they have to do is rest on the summons, because there's no hearsay statements, and the violation is issued.
Thank you.
Thank you.
May it please the court, Janet Zalian for oath. This obviously, the issue of the default penalties, as you mentioned, Your Honor, they were not only avoidable and remedial, but in fact, it's important to remember two things. The city charter provides for penalty upon default to the maximum extent provided by law, and the Department of Buildings promulgated a penalty schedule, which Supreme Court recognized that Oath had applied. There's no analogy to a penalty to the outcome of a breach of contract action. That simply doesn't apply here. The other thing that's important to remember is this is not a preservation case, because Windermere preserved their argument about the constitutionality. They raised it before Oath. But Oath stated that Oath does not feel it has the authority to handle a constitutional claim.
I'd like to focus on, look, the way I see the record here, there are about a handful of default orders that are issued, right? Because Oath did grant some of the motions to vacate, some were resolved, and so forth. So we're dealing with a handful of default orders still, correct?
Right.
And if I understand the record here, the basis or the extraordinary circumstances, because it's past the default and you're past the time to move the default, there has to be extraordinary circumstances, right? And I think the circumstance that they proffered was that their general counsel got sick and that, things fell through the cracks. What do you say to that? I mean, obviously you rejected that, right? Because why? Was it arbitrary and capricious in terms of you rejecting that excuse?
It would not be arbitrary and capricious because, first of all, there is no, apart from whether or not they had to disclose, who it was and what their health problem was, there is no indication that the summons that's issued to Windermere, it doesn't get sent from a DOB to a law office, it gets sent to Windermere. Windermere responded to some of these over time.
Oh, okay, right.
The ones you can see in the brief, there's a discussion of the Group A summonses that Windermere responded to in, one was in 2010, one was in 2016.
Well, according to the Supreme Court, you folks actually lined it all up. The petition kind of just had a very generalized argument in terms of seeking to overturn your decision, but you folks in your respondent's brief before the Supreme Court outlined everything, and the court was very thankful that you put everything in order.
Right, but and I'm sure that was very helpful to Supreme Court and to this court. But what it shows is that there was some understanding here. In fact, there's an email that also got that Windermere disclosed that also got made reference to violations that were settled. So Windermere was doing something here over time. And so what happened here is not a failure to follow precedent. One ALJ didn't have to follow another, just like one trial court doesn't have to follow another one, or even their own decision if they in a different case take another hard look and say, wait a minute, I don't know about this reasoning. They'd have to follow this court because this court, of course, is controlling. But when it comes to the ALJ's decision looking at the volume of these cases and the proof that was put in, and what they did, which is what the Charles Field delivery case requires, is the ALJ in the cases that were denied that are challenged here, the ALJ said, okay, I'm going to explain the reasoning. I'm not persuaded by what my colleagues did before. I'm going to explain the reasoning here, and provided an explanation. And of course, under the deferential standard of Article 78 review, determining whether that is a rational decision is all that's required. And the court, the ALJ simply said, I don't see proof here of what kept Windermere, a business, from finding out what its counsel was doing for a decade. Why wasn't there some understanding of what was going on here? Why didn't they find out? And that is a rational thing to be concerned about, because the standard is exceptional circumstances to avoid an injustice. And the other thing was that the prior cases, we don't know on those records what the time limit was. Whether it was, let's say, a motion within a year that had a lesser reasonable excuse standard. Thank you, Your Honors, for your attention.
One point on the excessive fines argument. Nowhere in the denial decisions does Oath say that they don't have authority. That's something that was made up in an Article 78. Even if it's true, it is not appropriate to bring a new argument in an Article 78 if it's not in the denial decisions. In terms of Oath's discussion about slender allegations, lack of proof, all of that, the difficult part of this case is to divorce oneself, separate oneself from our knowledge of CPLR 5015 and the proof that's required on such a motion. The standard that was set by Oath is a very lax one. Oath, all the court has to do is compare paragraph 25 of the petition with paragraph 34 of the petition. Paragraph 25 is what Windermere submitted. Paragraph 34 is what the other building owner submitted. It's exactly the same. So all of this discussion about lack of details would be absolutely relevant in a CPLR 5015 case, but it is not relevant here because the relevant authority is Oath. And one more point. It's important to note that the hearing division, if the hearing division decisions are not precedent, there is no ability to appeal within the agency on these types of motions. So if the hearing division decisions aren't precedent, then is Oath's position that they can just rule however they want?
Thank you very much.
Thank you.
People versus Rodriguez.
Good afternoon, Your Honors. May it please the Court. Cara Labini for Appellant Mr. Hernandez Santiago from the Center for Appellate Litigation. The prosecution concedes in this case that the murder one conviction should be dismissed and a resentencing ordered on the remaining counts. This court should also reduce the murder two and conspiracy convictions because there was no evidence beyond a reasonable doubt that Mr. Santiago, as an individual, 1, intended to cause death, 2, aided the principal in the killing, or 3, entered into an agreement to kill. Now, there is no doubt that this was a very brutal murder, and no one is contesting that. But the intent evidence as to Mr. Santiago was so weak that the prosecution, in summation, the best the prosecution could do in characterizing the evidence was to state that Mr. Santiago's actions did not disprove an intent to kill, and that's at page 2040 of the transcript. That is not proof beyond a reasonable doubt. That is hoping that the jury will make a leap based on evidence that's not there and based on the actions of others. But this court, an appellate court, must be more specific in tracking the actions of Mr. Santiago and in deciphering his intent. Ms. Grace, in her response brief, is very general in describing what happened that day. They chased him, they hunted him down, they stabbed him. But we must be more specific in paying attention to what Mr. Santiago did in order to understand and come to the conclusion that there was evidence beyond a reasonable doubt that he intended to kill the victim rather than cause serious physical injury. The prosecution did not even argue, and does not argue here, that Mr. Santiago helped the principal, nor that the victim's death was the natural, probable, and necessary consequence of Mr. Santiago's actions. There is nothing in the record showing that Mr. Santiago intended death rather than serious physical injury. It is undisputed what he did in this case. He walks during the chase where the other co-defendants are sprinting after the victim. He is late to the fray. He is the last to join the pile-on. And in fact, he's too late to help the principal commit this murder. By the time he arrives at the stabbing, the victim is already getting away and escaping back into the bodega. At worst, it is also undisputed that Mr. Santiago grazed the victim's leg and caused what this court recognized in the co-defendant's case, Mr. Estrella's case, were superficial injuries to his leg, which did not go below the top layer of skin. And the medical examiner's testimony insisted that those injuries would have required no more than an ointment to make sure they did not get infected. Mr. Santiago, just like his co-conspirators who testified at trial, expected that this attack would result in injury, not in death, just as the knife fight the day earlier had. Mr. Estrella, the principal in this case, went rogue. There was no evidence Mr. Santiago planned to kill the victim, as both co-conspirators also directly testified that there was no kill order when asked directly. There was no evidence Mr. Santiago knew that the principal had his most deadly weapon. There was no evidence he helped the principal, and the prosecution doesn't deny that, as I said. And now it's this court's job to look at the jury verdict and determine whether there was evidence beyond a reasonable doubt of Mr. Santiago's.
I'm sorry, wouldn't, looking at the evidence in the light most favorable to the people, would you not agree that Mr. Santiago was part of a group acting in concert, that they left that meeting with their captain to look for a sunset person in Little Italy? They went with the purpose, acting in concert to find someone with the instruction to use knives, weapons, whatever it is, to do damage. Wouldn't that work here? And there was a community purpose together with Mr. Estrella, who was the principal who actually killed him?
That is not the standard to apply in a weight of the evidence claim. The standard, the question before this court now, is whether a reasonable juror could have found that there was no intent to kill, and whether there was evidence beyond a reasonable doubt, and whether the verdict was against the weight of the evidence. Now, this is not a sufficiency claim. As to, Your Honor referenced the claim kind of to do any sort of damage. I believe that was the co-conspirator Sosa who testified as to that statement in particular. There's several problems with relying on his testimony, which is why in my reply brief, I made a point of pointing out that the prosecution had wrongly attributed that comment to Mr. Alvarez rather than Mr. Sosa. Mr. Sosa was part of a different set of the Trinitarios, and the evidence that he gave as to the orders he received was not specific of the order that the defendants at trial received from their set. He also clarified that that was not a kill order. Both co-conspirators testified, were directly asked, so did you understand this was an order to kill? And they both said no. They both said
Thank you very much. Have time rebuttal.
Good afternoon, Your Honors, and may it please the Court. Reva Grace Phillips for the Office of the Bronx County District Attorney, the respondent. First, I won't be general as counsel has accused me of being in my brief. I'll be very specific to this defendant today. First, I claim, or I want to point out, and defendant concedes this is unpreserved, the challenge to the second-degree murder conviction. It's entirely unpreserved. Second, as to the murder, there's very specific proof of this individual defendant's intent. If Your Honors look at the video evidence we submitted to this court at timestamp 1608, you can see this defendant for a few seconds of the clip. Most of his conduct's not captured by the camera just because he's lucky and happens to be off camera. But at 1608 on the timestamp, you will see him try to grab the kid as he's running away, and then you will see him vigorously stab forward with a large knife. So large that you can actually see its reflection in the video. And that comports with Kevin Alvarez's testimony that he observed him carrying a large kitchen knife. Defendant's counsel just tried to claim that the injury he inflicted would have been to his leg. I think the video makes clear that he was attempting to stab him in or about the neck, and that in fact, if Lisandro Jr. Guzman Feliz had been about 6 inches backwards at the time as he was trying to run into the bodega to seek safety, he would have been stabbed in the back of the neck by this defendant. So his individual intent is absolutely crystal clear from that video evidence. He is stabbing in the area of vital organs. The medical examiner testified to 9 sharp object injury wounds. Those were to the boy's torso, back, neck, and face, all areas where one would reasonably expect stabbing him with a large kitchen knife would kill him. As to the acting in concert claim, counsel argues in her brief that there could be no proof of acting in concert because he joined the fray too late. To get very specific about this defendant's conduct, Kevin Alvarez tells us he's the first one to get out of the car. He approaches Junior on the street alongside lead defendant Estrella first, that they are the first two to approach Junior on the street, which kicks off the whole chase. Doesn't deny that he participates in the chase at all. Participates in chasing the boy into the bodega. And this is all, again, after he's led the group to Little Italy in the first place. As a former Sunset, he's the one who tells the gang, if we want to go and find a Sunset to Herz tonight, we're going to Little Italy. And in fact, Kevin Alvarez testifies that he gets in his car and he gives him directions where to go. So, I think the idea that there's not evidence of his individual intent is belied by the camera. I think the acting in concert theory is belied by Kevin Alvarez's testimony about how involved he is in directing the gang's actions from the outset. Turning a bit to the conspiracy, to the extent that the co-conspirators, or the cooperators rather, give slightly different testimony, I want to be very clear about this. We can see that Kevin Alvarez repeatedly sort of testifies there's no kill order. He says the order, as he understands it, is to do whatever damage possible, and that this is amidst escalating gang tensions where he's been previously told to keep a weapon on him and do any kind of damage he can to a Sunset. But Reyes doesn't, at any point, say there's no kill order. In defendant's brief at page 7, they make 2 transcript references for this allegation. Transcript 1424, there's nothing about the kill order there. And transcript page 1714, and that's, I don't think, an accurate description here. What actually happens is on cross-examination, Reyes is asked, did you ever hear that there was an order to kill Junior? Answer, no ma'am. Question, to your knowledge there was no such order, is that correct? Answer, not to kill Junior. I think the implication there is plain. Not to kill this specific boy, we were told to go out and kill a Sunset. And in fact, another defense counsel at transcript 1754, different defense counsel on cross, attempts to get this same answer out of him, no kill order. And instead of giving him that answer, Reyes again reiterates, I understood the order to be if you have a pistol, shoot. If you have a machete, you use it. And if you have a knife, you use it. He plainly understood the order. And whether or not, and I think in terms of squaring these 2 cooperators' testimony, this is exactly why appellate courts afford great deference to the finder of fact at trial. They're able to watch these 2 men under testimony. They're able to watch and observe them as they give these answers. But even if you leave aside that testimony, I think their coordinated conduct underscores the plan. They have a meeting beforehand. They go out. This defendant elects to arm himself while other people are in the bodega Tamika Jones, unrelated eyewitness, testifies that she hears one of the gang leaders on the street tell them to bring him out of the bodega because there are video cameras in there. Why bring him out of the bodega where there are video cameras if the intent is just to engage in a fist fight? They're already beating him in the bodega. They pull him out because they mistakenly don't think there will be cameras there to capture their brutal knife stab murder of this boy. This defendant runs up with a giant knife. He tries to use it. His lack of success doesn't underscore his lack of intent. And then they regroup. They regroup back at the gang leader's house. There's absolutely evidence that they agreed to go out and do this. They armed themselves beforehand. They engaged in a coordinated attack. They then regroup. They then hide together in Paterson, New Jersey, consciousness of guilt. If your honors want me to briefly touch on the excessive sentence point, I can do that. This guy was a senior member. He's 24. Of the 5 men who were charged with...
Given that you've conceded on the first degree, wouldn't this have to go back for resentencing in any case?
Your Honor, we do believe this will go back for the limited purpose of vacating the first-degree murder and vacating that sentence. We wouldn't necessarily concede that the remaining sentences would be up for grabs, and we don't think it would be appropriate. As defense counsel herself just conceded, this was a very brutal murder, as this court found in Estrella, which both I know your honors were on that panel. This was an especially heinous second-degree murder. This was one of the older men involved in the attack. He was a senior member of the Trinitarios that night. He was an active participant. The fact that he was slow is no excuse for the fact that he was a part of a lethal group. And so I would ask your honors.
You don't believe it should go back for resentencing?
Your honors, I think that we believe procedurally it would go back to the sentencing court to vacate the sentence and vacate the...
Because it was in the aggregate, right? Am I mistaken? The sentence was in the aggregate?
Yes, your honor. So Estrella was the
can't
only...
parcel out which sentence is for what, or...
Oh, well, no, the court below did put a sentence on each charge, or each conviction, pardon me. And there would...
It would be possible to vacate just the sentence for the first-degree murder and uphold the remaining sentences?
Yes, Your Honor, we believe so, and we believe that would be appropriate. And I believe that co-defendant Estrella had a resentencing proceeding, which is the only reason that I'm saying, I think that we believe procedurally that would be appropriate. I don't think it would change his sentence, and our argument is certainly that the remaining sentences should not be altered.
Is that true for both the cases, that they broke out for both the defendants, that they broke out the sentences?
So Defendant Rivera, you mean here? Defendant Rivera here doesn't even make an excessive sentence claim. He was actually the only one of the 5 men who didn't get, so lead defendant Estrella was the only one who got life without parole, and that was tied to the first-degree murder. He now has a 25 to life sentence. Rivera was the only one of the 5 men who didn't get 25 to life in the aggregate. In recognition of the fact that he was the youngest of the men, he was only 18. The sentencing court gave him 23 to life. Yeah, exactly.
Okay.
And this defendant got 25.
Thank you very much.
Thank you, Your Honors.
My adversary started her response off by saying that Mr. Santiago attempted to stab the victim at the neck and at his vital organs. That argument has never been made, not at trial and not in their briefs. Other than that, the coordinated conduct that occurred is completely consistent with an intent to cause physical injury, not with an intent to kill.
I just want to ask you a question. Now, Santiago was previously a member of the Sunset Set, right?
Yes, Your Honor.
And then, he was promoted to first soldier, and that usually means you either kill someone or cause some serious harm. So he was a first soldier, correct?
None of that's part of the record. What I do know from the record, in terms of how
I thought I saw that in the transcript that he rose to the rank of a first soldier. I thought that was
yes, that he has that that rank.
That's what I'm talking about.
Record as to how he got.
But there was testimony.
But there also defense counsel at sentencing put in a sentencing letter stating that he had left the gang until February, 2 months prior to this offense.
Then went back.
He did, because he was pressured to rejoin, and he attended something like 2 meetings.
Yeah.
And then was lackadaisical in his participation.
Just one more. So he's a first soldier, and part of the instructions, if you have a knife, you stab, cause harm. That was part of the instructions, right?
That is completely consistent with an intent to cause serious physical injury, and not evidence beyond a reasonable doubt of an intent to kill.
Okay. So I just have one last question about the sentencing. Do you agree with that we don't need to send it, if what we decide to do ultimately is vacate the first degree and not the other counts, do you agree that we do not have to send it for resentencing?
Well, in Mr. Estrella's appeal, this court sent it back for a resentencing on the remaining counts. So our position would be that the remaining counts have to be resentenced and that it would be a plenary
Did the court break it
resentencing.
out below what sentence it was given for each
Yes,
offense?
that's
Why does
part of
that
the
have to be
record.
sent down for, because we did in the other case?
Yes, and I believe procedurally that's correct.
Thank you.
Thank you.